Good morning. Welcome to this live broadcast. This is a special sitting of the Senate. This broadcast is brought to you by the Parliamentary Broadcasting Unit in partnership with the Kenya Broadcasting Corporation. My name is Kamche Menza. This Thursday morning of the April 29th, 2021, the Senate members will be debating the Constitution of Kenya Amendment Bill 2020. This debate is a resumption of the debate interrupted on the afternoon of Wednesday, 28th of April 2021, when the Senate members convened for a morning session before it was interrupted. Thereafter proceeded for an afternoon session and adjourned in the evening. This is the resumption of the debate interrupted on Wednesday, 28th April 2021, the afternoon sitting. Thereafter, the Senate members will consider the bill in the Committee of the Whole. The proposed constitutional reforms originate from the views of citizens expressed through the Building Bridges initiative, that is the BBI. Through the BBI, citizens from all corners of the country shared their concerns and views on issues ranging from their responsibilities and rights, national ethos and responsible citizenship, corruption, productivity and shared prosperity, devolution, divisive elections, ethnic antagonism, inclusivity and security, among others. This bill focuses on these issues with an overriding objective of promoting a cohesive society and to further the ideals of a united, prosperous and just nation. Some of the clauses that the bill seeks to amend include Clause 10 of the bill, which proposes to amend Article 89, the limitation of electoral units, to increase the number of constituencies from the current 290 constituencies to 360 constituencies. This is to facilitate attainment of fair representation in the National Assembly and to actualize the aspiration of the equality of the vote principle, especially in the current underrepresented electoral areas. The bill also seeks to amend a Clause 11 that proposes to amend Article 90, that is the allocation of party list seats, to promote the principle of equality of the vote and entrench ideals of a transparent electoral process. The proposed amendment provides the candidates to be nominated from a party list for seats in the National Assembly, and county assemblies shall be allocated on the basis of the total votes received by their political party. As opposed to the current practice where such allocation is based on seats won by a political party. The bill also seeks to amend Chapter 10 of the Constitution on the judiciary to provide for more transparency in the judicial processes. The proposed amendments provide for the finality of the decisions of Court of Appeal in petitions concerning an election and limits the tenure of the President of the Court of Appeal and High Court to 5 years. The amendments further provide for the tenure of the Deputy Chief Justice. Okay, there's some activity at the entrance of the Senate. And the Speaker of the Senate, Kenneth Lusaka, has just entered the chambers. I will now hand you over to the live broadcasting. This is a live broadcast in partnership of Kenya Broadcasting Corporation and the Parliamentary Broadcasting Unit. Welcome. My name is Kamche Menza.
Let us pray. Almighty God, we beseech you to behold with your abundant favor and blessings us, your servants, whom you have been pleased to call to leadership positions in this republic. We seek guidance to treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen. Okay.
Order number 1, communications from the chair. Order number 2, the Constitution of Kenya Amendment Bill 2020, second reading.
The Senate Chair Mogeni had a balance of 20 minutes. So, yeah. Is the chair.
Thank you, Mr. Speaker. Mr. Speaker, when you were adjourning yesterday, a point of order was raised by a senator for Muranga, Senator Kangata, on what is contained in page 97 and page 98 of the report that has been tabled before the floor. Mr. Speaker, in my brief life, I always like speaking the truth and being very candid. And what is contained in this report is nothing other than the truth and the whole truth. Mr. Speaker, when we retreated as the joint committees of the two houses, as you can see at page 97 and page 98, we did call for the bills that were tabled before the respective houses. And Mr. Speaker, what the remarks that you can see in page 97 is the anomalies that were picked on the two bills, the one that was tabled before the National Assembly and the one that was tabled before the Senate. And Mr. Speaker, Senator Kangata was a member of our committee, and he sat as we deliberated on this issue. And Mr. Speaker, what we have, the observations we have made to the House is that there were some differences on some clauses on the bills that were the bill that was read in the National Assembly and the bill that was read in the Senate. Mr. Speaker, regarding subclause 3B, the bill that was read in the National Assembly was amending Article 97, sub-Article 2. The bill that was read before the Senate was amending Article 97, sub-Article 3. So clearly, Mr. Speaker, we did make an observation that there were differences in terms of what was being amended on the bill that was read in the National Assembly and the one that was read before the Senate. Regarding clause 48, Mr. Speaker, of the bill, we made an observation, Mr. Speaker, that whereas the bill was amending Article 188, on the marginal notes, reference was made to Article 189. And finally, Mr. Speaker, we did make an observation that in the second schedule of the bill, Section 1, subsection 1, the bill that was read before the National Assembly was amending Article 89, sub-Article 7. The bill that was read before the Senate was amending Article 87, sub-Article 7. So, Mr. Speaker, plainly, and I hope members have read this report, what we are telling the House is that the bill that was read before the Senate has some errors on the face of the record. And we have made a proposal, Mr. Speaker, that this House, and that is at page 65, this House should take legislative action to correct the errors of form that appear on the bill. So what we are saying, Mr. Speaker, is that the person who has moved this bill, that's the majority leader, has an option, Mr. Speaker, of moving an amendment to correct the error of form. And if you read the report, Mr. Speaker...
Let's consult in low tones. You know, what is raising a very important matter. Honorable.
Mr. Speaker, if you read this report, we had two experts, Mr. Speaker, Professor Kamiri Mbote and Dr. Collins Odote. And they did point out, Mr. Speaker, that if we identify an error of form, not an error of substance which changes the wishes of the promoters of the bill, we can make steps to amend the bill to correct those errors. Mr. Speaker, I want to state that I'm not the author of the errors that appear in this bill. I'm not the author. And I've seen debates on social media that there were two bills. Whether there were two bills or one bill, I don't know. The only business that we had to undertake as a committee is to scrutinize each clause of the bill, make observation, and report back to the House. And Mr. Speaker, I'm sure that even His Excellency the President and the Right Honorable Prime Minister, the owner of the handshake, they are not going to kill any of us if we correct this mistake on this bill. Nobody is going to say we have committed a mistake by correcting this error. And Mr. Speaker, I want this House to note that the bill that is being considered at the National Assembly does not have these errors. So don't look at what is happening on the other side. The error on this bill refers to the bill that was read before the Senate. So the task of seeing how to correct those errors is only with this House. And Mr. Speaker, we have proposed that the leadership, that is the move of this bill, takes steps to correct that error. How will we look to the Kenyan people, Mr. Speaker, if we consider a bill that has got these typing errors, and we fail in our duty as members of the Senate in correcting these simple errors? And then you send a bill to the people that has got these glaring errors. Mr. Speaker, I want to persuade the House that this is an error that does not change the substance of the bill. So we are not changing the intention of the promoters. We're just doing an amendment that will correct errors that appear on the face of the bill that was read before us. So, Mr. Speaker, the next point I was making yesterday was regarding the clauses on the judiciary. And Mr. Speaker, some people did not get the point I was making. Mr. Speaker, if you read Article 172 of the current Constitution, the Judicial Service Commission still retains the power of considering complaints that are made against judges. And I want to read what is in Article 172C. It says that the function of the JSC will be to receive complaints against judges, to investigate and remove from office or otherwise discipline registrars, magistrates, and other staff in a manner prescribed by an act of parliament. Mr. Speaker, the current position is that you cannot suspend a judge of the High Court, Court of Appeal, or the Supreme Court before Judicial Service Commission has recommended to the President the setting up of a tribunal to look into the conduct of a judge of a superior court. Now, the clause that that the committee has an issue with is what is in clause 43, Mr. Speaker, whereby it is now proposed that just by the mere receiving of a complaint, before that complaint is looked at and a determination made that a tribunal should be formed to look into the conduct of the judges, Judicial Service Commission can now suspend a judge. And then later on even say, we have looked at the complaint and we have found it unmerited, and you are free to go back and perform the functions of your office. What we are saying as a committee, Mr. Speaker, is that this will be a big clawback on the independence of the judiciary. It will create a lot of fear among judges, and we are proposing that the prevailing situation where judges are suspended only after a recommendation has been made to form a tribunal should remain as it is. That's why we have termed that particular amendment to the Constitution as being unconstitutional. Mr. Speaker, the other clause that we looked at was clause 2 or 3. Now, Mr. Speaker, on this particular one, there is a proposed amendment to this Constitution in clause 50, Mr. Speaker, where there is a new clause. That is clause N, and I could read that clause to the House, which reads, to ensure that the average amount of money allocated per person to account with the highest allocation does not exceed 3 times the average amount per person allocated to account with the lowest allocation. Mr. Speaker, if you look at the findings of the committee, and this is at page 166 of our report, Mr. Speaker, we have analyzed this provision vis-a-vis clause Article 217 of the Constitution, which provides that in every 5 years, the Senate will come up with a resolution to determine the basis for allocating money among counties. And Mr. Speaker, we had an assimilation that was done to us by the Parliamentary Budget Office. And Mr. Speaker, if we were to apply that new clause, 203N, there are a number of counties that will automatically be disadvantaged. And a county like Tana River will immediately lose 2.3 billion if that clause was to take effect. A county like Samburu will lose 1.2 billion. A county like Marsabit will lose 1.2 billion. A county like Isiolo will lose 1.1 billion. Lamu will lose 435, Turkana will lose 435 billion. Taita Taveta will lose 368 million. So this is a matter that you may not see this debate being vibrant in the National Assembly, because this is a matter that is handled almost exclusively by the Senate. It's us who understand that our role really is to defend county governments and the people who reside in those counties. So when we look at all these factors, Mr. Speaker, and considering the fact that the last resolution that was passed by this House stated very clearly that no county should be allowed to lose money, we made a conclusion, Mr. Speaker, that this proposed Article 203N will be in clear conflict with the provisions of Article 217 of the Constitution. And we said, Mr. Speaker, that should this bill pass, then the executive and Parliament will again be called upon to put in place mechanisms that will ensure that no counties are disadvantaged. So we made a conclusion that that article, in our opinion, is problematic, is undesirable, and that it will interfere with the provisions of Article 203(1) of the Constitution, more so on issues of affirmative action, whereby, Mr. Speaker, some of the counties that have been lagging behind in development must be supported with more resources so that they catch up with other parts of Kenya, and that we must also ensure that there is a stable and predictable allocation of resources to counties. Mr. Speaker, if these counties were to lose this money, it will make their budgeting and financial planning to be almost impossible. Madam Speaker, the other clause that we looked at is clause 230. I mean, the proposed amendments to clause 230, that is the one that deals with salaries and remuneration commission. That is clause 61 of the bill. Mr. Speaker, if you look at the current architecture of that clause, clause 230 of the current Constitution, Article 230 of the current Constitution, Mr. Speaker, the composition of SRC includes one representative of the Parliamentary Service Commission, one representative of the Public Service Commission, one representative of Judicial Service Commission, one representative of the Teachers Service Commission, the National Police. Then the Senate picks one representative on behalf of the county governments. And then we have one representative representing the trade unions, one representative representing employers, and then one representative representing the Joint Forum of Professional Bodies. Mr. Speaker, having listened to stakeholders, and I must say that one of the stakeholders was Senator Kasanga, who appeared before us. Mr. Speaker, an issue arose that this proposed amendment to Article 230, where all these bodies will be removed and then replaced with 7 commissioners picked by the President and then vetted only by the National Assembly and not by the Senate. Yet they will set terms for both members of National Assembly and the members of the Senate is highly objectionable. Mr. Speaker, we also looked at how SRC will be able to determine terms for professionals, including engineers, quantity surveyors, providing service to county and national and county governments. And we found that this article will most likely be very problematic. And therefore, Mr. Speaker, we propose that in future, there will be need to relook at this particular article. Now, Mr. Speaker, the other point that was very controversial is the second schedule of this proposed bill. Mr. Speaker, on the issue of the proposed 70 constituencies, we looked at it from two angles, Madam Mr. Speaker. The first one is the process leading to the creation of the 70 constituencies. And Mr. Speaker, we went through all the BBI reports and they are contained in this report that was tabled before the House. And Mr. Speaker, we looked at the initial task force. When they released their first reports, there was nowhere where there was a mention of an additional 70 constituencies and the 28 counties that were to benefit. The task force that was appointed to validate the report that was released by the first task force never mentioned these 70 constituencies anywhere. Mr. Speaker, the MP for Bobasi, and I will not refer to the exact page because of time, and the senator for Kitui appeared before the committee during the public hearing, and they took us to task, Mr. Speaker, to show them where the BBI team held public hearings, where Kenyans gave views as to which county should benefit from these 70 constituencies. And Mr. Speaker, we had no answers. Therefore, the process that was followed to allocate these 70 constituencies to 28 counties and leave out 19 does not have answers within BBI. Number two, Mr. Speaker, we invited two critical bodies, Kenya National Bureau of Statistics and Independent Electoral and Boundaries Commission. Madam Speaker, when Kenya National Bureau of Statistics appeared before us, they took us through the population data in their possession, and then they took us through the formula of population per constituency that can be used to share out these constituencies. Mr. Speaker, their verdict, and it is here in this report, was that at least 5 counties were unfairly denied constituencies. They identified the county of Kitui, they identified the county of Kisii, they identified the county of Meru, they identified at least in total 5 counties. And Mr. Speaker, they said if we used a proper formula, those counties should have been allocated additional constituencies. So, Mr. Speaker, when we asked IBC whether they were consulted, whether there was any public hearings before these constituencies were allocated to these 28 counties, Mr. Speaker, IEBC appeared before us and stated, and it is in this report, that they were never consulted and they were never involved on the allocation of these 70 constituencies. Now, what is even serious, Mr. Speaker, is that IBC told us that BBI task, Mr. Speaker, I hope you can add me more time, 10 minutes.
No.
Now, Mr. Speaker,
order. You know,
when,
just a minute. You know, when they ask the speaker, not everybody is a speaker. So I hear, I am following. I'll add him 5 minutes.
Thank you. Yeah. Mr. Speaker, those who read the report, they can look at the submissions by the senator for Kitui at page 147 and the MP for Kisii at 147. So what IBC told us, Mr. Speaker, is that page 147. What IBC told us, Mr. Speaker, is that under the provisions of Article 88, sub-Article 4, and Article 89, sub-Article 5 and 7, they are the only ones that have the constitutional mandate of delimitation of boundaries. And even then, they told us, Mr. Speaker, that they only do so after they have accorded an opportunity to all Kenyans to make their views on those constituencies. And then they told us, Mr. Speaker, that even after the exercise has been concluded, invoking the provisions of Article 89(10), they still must give another leeway for any dissatisfied Kenyan to go to court and challenge that process. And the judiciary is given a period of 3 months, to resolve that dispute. So what IBC told us, Mr. Speaker, is that what is provided in the
Sauti iko ama hakuna? Can you feel me? Can you get me? Good morning. Welcome to this live broadcast. Good morning. Welcome to this live broadcast. This is a special sitting of the Senate. This broadcast is brought to you by the Parliamentary Broadcasting Unit in partnership with the Kenya Broadcasting Corporation. My name is Kamche Menza. This Thursday morning of the April 29th, 2021, the Senate members will be debating the Constitution of Kenya Amendment Bill 2020. This debate is a resumption of the debate interrupted on the afternoon of Wednesday, 28th of April 2021, when the Senate members convened for a morning session before it was interrupted. Thereafter proceeded for an afternoon session and adjourned in the evening. This is the resumption of the debate interrupted on Wednesday, 28th April 2021, the afternoon sitting. Thereafter, the Senate members will consider the bill in the committee of the whole. The proposed constitutional reforms originate from the views of citizens expressed through the Building Bridges initiative, that is the BBI. Through the BBI, citizens from all corners of the country shared their concerns and views on issues ranging from their responsibilities and rights, national ethos and responsible citizenship, corruption, productivity and shared prosperity, devolution, divisive elections, ethnic antagonism, inclusivity and security, among others. This bill focuses on these issues with an overriding objective of promoting a cohesive society and to further the ideals of a united, prosperous and just nation. Some of the clauses that the bill seeks to amend include Clause 10 of the bill, which proposes to amend Article 89, delimitation of electoral units, to increase the number of constituencies from the current 290 constituencies to 360 constituencies. This is to facilitate attainment of fair representation in the National Assembly and to actualize the aspiration of the equality of the vote principle, especially in the current underrepresented electoral areas. The bill also seeks to amend a Clause 11 that proposes to amend Article 90, that is the allocation of party list seats, to promote the principle of equality of the vote and entrench ideals of a transparent electoral process. The proposed amendment provides the candidate to be nominated from a party list for seats in the National Assembly, and county assemblies shall be allocated on the basis of the total votes received by their political party. As opposed to the current practice where such allocation is based on seats won by a political party. The bill also seeks to amend Chapter 10 of the Constitution on the judiciary to provide for more transparency in the judicial processes. The proposed amendments provide for the finality of the decisions of Court of Appeal in petitions concerning an election and limits the tenure of the President of the Court of Appeal and High Court to 5 years. The amendments further provide for the tenure of the Deputy Chief Justice. Okay, there's some activity at the entrance of the Senate. And the Speaker of the Senate, Kenneth Lusaka, has just entered the chambers. I will now hand you over to the live broadcasting. This is a live broadcast in partnership of Kenya Broadcasting Corporation and the Parliamentary Broadcasting Unit. Welcome. My name is Kamche Menza.
Let us pray. Almighty God, we beseech you to behold with your abundant favor and blessings, as your servants whom you have been pleased to call to leadership positions in this republic. We seek guidance to treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen. Okay.
Order number 1, communication from the chair. Order number 2, the Constitution of Kenya Amendment Bill 2020, second reading.
The Senate Chair Mogeni had a balance of 20 minutes. So, yeah. Is the chair.
Thank you, Mr. Speaker. Mr. Speaker, when you were adjourning yesterday, a point of order was raised by a senator for Muranga, Senator Kangata, on what is contained in page 97 and page 98 of the report that has been tabled before the floor. Mr. Speaker, in my brief life, I always like speaking the truth and being very candid. And what is contained in this report is nothing other than the truth and the whole truth. Mr. Speaker, when we retreated as the joint committees of the two houses, as you can see at page 97 and page 98, we did call for the bills that were tabled before the respective houses. And Mr. Speaker, the remarks that you can see in page 97 is the anomalies that were picked on the two bills, the one that was tabled before the National Assembly and the one that was tabled before the Senate. And Mr. Speaker, Senator Kangata was a member of our committee, and he sat as we deliberated on this issue. And Mr. Speaker, what we have, the observations we have made to the House is that there were some differences on some clauses on the bills that were the bill that was read in the National Assembly and the bill that was read in the Senate. Mr. Speaker, regarding subclause 3B, the bill that was read in the National Assembly was amending Article 97, sub-Article 2. The bill that was read before the Senate was amending Article 97, sub-Article 3. So clearly, Mr. Speaker, we did make an observation that there were differences in terms of what was being amended on the bill that was read in the National Assembly and the one that was read before the Senate. Regarding clause 48, Mr. Speaker, of the bill, we made an observation, Mr. Speaker, that whereas the bill was amending Article 188, on the marginal notes, reference was made to Article 189. And finally, Mr. Speaker, we did make an observation that in the second schedule of the bill, Section 1, subsection 1, the bill that was read before the National Assembly was amending Article 89, sub-Article 7. The bill that was read before the Senate was amending Article 87, sub-Article 7. So, Mr. Speaker, plainly, and I hope members have read this report, what we are telling the House is that the bill that was read before the Senate has some errors on the face of the record. And we have made a proposal, Mr. Speaker, that this House, and that is at page 65, this House should take legislative action to correct the errors of form that appear on the bill. So what we are saying, Mr. Speaker, is that the person who has moved this bill, that's the majority leader, has an option, Mr. Speaker, of moving an amendment to correct the error of form. And if you read the report, Mr. Speaker...
Let's consult in low tones. You know, it's raising a very important matter. Honorable.
Mr. Speaker, if you read this report, we had two experts, Mr. Speaker, Professor Kamiri Mbote and Dr. Collins Odote. And they did point out, Mr. Speaker, that if we identify an error of form, not an error of substance which changes the wishes of the promoters of the bill, we can make steps to amend the bill to correct those errors. Mr. Speaker, I want to state that I'm not the author of the errors that appear in this bill. I'm not the author. And I've seen debates on social media that there were two bills. Whether there were two bills or one bill, I don't know. The only business that we had to undertake as a committee is to scrutinize each clause of the bill, make observation, and report back to the House. And Mr. Speaker, I'm sure that even His Excellency the President and the Right Honorable Prime Minister, the owner of the handshake, they are not going to kill any of us if we correct this mistake on this bill. Nobody is going to say we have committed a mistake by correcting this error. And Mr. Speaker, I want this House to note that the bill that is being considered at the National Assembly does not have these errors. So don't look at what is happening on the other side. The error on this bill refers to the bill that was read before the Senate. So the task of seeing how to correct those errors is only with this House. And Mr. Speaker, we have proposed that the leadership, that is the move of this bill, takes steps to correct that error. How will we look to the Kenyan people, Mr. Speaker, if we consider a bill that has got these typing errors, and we fail in our duty as members of the Senate in correcting these simple errors? And then you send a bill to the people that has got these glaring errors. Mr. Speaker, I want to persuade the House that this is an error that does not change the substance of the bill. So we are not changing the intention of the promoters. We're just doing an amendment that will correct errors that appear on the face of the bill that was read before us. So, Mr. Speaker, the next point I was making yesterday was regarding the clauses on the judiciary. And Mr. Speaker, some people did not get the point I was making. Mr. Speaker, if you read Article 172 of the current Constitution, the Judicial Service Commission still retains the power of considering complaints that are made against judges. And I want to read what is in Article 172C. It says that the function of the JSC will be to receive complaints against judges, to investigate and remove from office or otherwise discipline registrars, magistrates, and other staff in a manner prescribed by an act of parliament. Mr. Speaker, the current position is that you cannot suspend a judge of the High Court, Court of Appeal, or the Supreme Court before Judicial Service Commission has recommended to the President the setting up of a tribunal to look into the conduct of a judge of a superior court. Now, the clause that that the committee has an issue with is what is in clause 43, Mr. Speaker, whereby it is now proposed that just by the mere receiving of a complaint, before that complaint is looked at and a determination made that a tribunal should be formed to look into the conduct of the judges, Judicial Service Commission can now suspend a judge. And then later on even say we have looked at the complaint and we have found it unmerited, and you are free to go back and perform the functions of your office. What we are saying as a committee, Mr. Speaker, is that this will be a big clawback on the independence of the judiciary. It will create a lot of fear among judges, and we are proposing that the prevailing situation where judges are suspended only after a recommendation has been made to form a tribunal should remain as it is. That's why we have termed that particular amendment to the Constitution as being unconstitutional. But Mr. Speaker, the other clause that we looked at was clause 203. Now, Mr. Speaker, on this particular one, there is a proposed amendment to this Constitution in clause 50, Mr. Speaker, where there is a new clause. That is clause N, and I could read that clause to the House, which reads, to ensure that the average amount of money allocated per person to account with the highest allocation does not exceed 3 times the average amount per person allocated to account with the lowest allocation. Mr. Speaker, if you look at the findings of the committee, and this is at page 166 of our report, Mr. Speaker, we have analyzed this provision vis-a-vis clause Article 217 of the Constitution, which provides that in every 5 years, the Senate will come up with a resolution to determine the basis for allocating money among counties. And Mr. Speaker, we had an assimilation that was done to us by the Parliamentary Budget Office. And Mr. Speaker, if we were to apply that new clause, 203N, there are a number of counties that will automatically be disadvantaged. And a county like Tana River will immediately lose 2.3 billion if that clause was to take effect. A county like Samburu will lose 1.2 billion. A county like Marsabit will lose 1.2 billion. A county like Isiolo will lose 1.1 billion. Lamu will lose 435, Turkana will lose 435 billion. Taita Taveta will lose 368 million. So this is a matter that you may not see this debate being vibrant in the National Assembly, because this is a matter that is handled almost exclusively by the Senate. It's us who understand that our role really is to defend county governments and the people who reside in those counties. So when we look at all these factors, Mr. Speaker, and considering the fact that the last resolution that was passed by this House stated very clearly that no county should be allowed to lose money, we made a conclusion, Mr. Speaker, that this proposed Article 203N will be in clear conflict with the provisions of Article 217 of the Constitution. And we said, Mr. Speaker, that should this bill pass, then the executive and Parliament will again be called upon to put in place mechanisms that will ensure that no counties are disadvantaged. So we made a conclusion that that article, in our opinion, is problematic, is undesirable, and that it will interfere with the provisions of Article 203(1) of the Constitution, more so on issues of affirmative action, whereby, Mr. Speaker, some of the counties that have been lagging behind in development must be supported with more resources so that they catch up with other parts of Kenya, and that we must also ensure that there is a stable and predictable allocation of resources to counties. Mr. Speaker, if these counties were to lose this money, it will make their budgeting and financial planning to be almost impossible. Madam Speaker, the other clause that we looked at is clause 230. I mean, the proposed amendments to clause 230, that is the one that deals with salaries and remuneration commission. That is clause 61 of the bill. Mr. Speaker, if you look at the current architecture of that clause, clause 230 of the current Constitution, Article 230 of the current Constitution, Mr. Speaker, the composition of SRC includes one representative of the Parliamentary Service Commission, one representative of the Public Service Commission, one representative of Judicial Service Commission, one representative of the Teachers Service Commission, the National Police. Then the Senate picks one representative on behalf of the county governments. And then we have one representative representing the trade unions, one representative representing employers, and then one representative representing the Joint Forum of Professional Bodies. Mr. Speaker, having listened to stakeholders, and I must say that one of the stakeholders was Senator Kasanga, who appeared before us. Mr. Speaker, an issue arose that this proposed amendment to Article 230, where all these bodies will be removed and then replaced with 7 commissioners picked by the President and then vetted only by the National Assembly and not by the Senate. Yet they will set terms for both members of National Assembly and the members of the Senate is highly objectionable. Mr. Speaker,
the committee has stated, and this is something that has happened in various different jurisdictions, that, Mr. Speaker, and I hold, that the power to amend a constitution is what we call constituted power, Mr. Speaker. Mr. Speaker, it is different from constituent power and is not the power to destroy the system created by a constitution. And I will explain. Parliament cannot usurp the sovereign power of an individual Kenyan or groups of Kenyans to actually exercise their sovereignty as per Article 1 of the Constitution, Mr. Speaker. Mr. Speaker, Article 1 of our Constitution is very clear. It says that all sovereign power belongs to the people, and the people can exercise it directly or in accordance with the Constitution, Mr. Speaker. Mr. Speaker, a plebiscite or a referendum is one of the events when the sovereign do what we call direct exercise of their sovereignty, Mr. Speaker. Mr. Speaker, there have been many different discussions of this, even in our country. If you look at the CKRC, the Constitution of Kenya Review Commission, in its final report, they stated that the purpose of including that Article 1 in our Constitution was to acknowledge the Constitution and the fact that ultimately the Constitution is a product of and must serve the aspirations of the people. Mr. Speaker, in Njoya versus Attorney General, the court considered that issue of constituent power. And it said that, and Justice Ringera, and I will quote him, Mr. Speaker, Justice Ringera said, the sovereignty of the people necessarily beckons that they have a constituent power, the power to constitute and or reconstitute, as the case may be, the framework of their government. That power is with the people. That power is a primordial one. Mr. Speaker, it is a basis for the creation of the Constitution, and it can therefore not be granted or referred to by the Constitution, Mr. Speaker. And finally, Professor Nwabwezi, Mr. Speaker, in his book, Ideas and Facts in Constitution Making, he summarizes what I'm calling constituent power as the authority to approve and adopt a constitution. And he says, the notion of the people as a constituent power is only an integral part of the wider concept of the people as a repository of the totality of a country's sovereignty, Mr. Speaker. Constituent power being the crowning point of sovereignty. So there's only one case that was referred to in this report, if you look at it. And that case that was referred to, where the issue of constitutionality arises, was a case in India. Mr. Speaker, in this case, which is Bharati versus State of Kerala, Minerva Mills Limited versus Union of India, the courts held, and that's another one, that and that's what the chairman is saying, that the courts can then declare later that this schedule is unconstitutional, but they held that they can only declare that amendment of the Constitution unconstitutional if it interferes with the basic structure of the Constitution. Meaning that the people, through a popular initiative, can decide to amend anything so long as they do not go to what we call the basic structure of our Constitution. Mr. Speaker, if you look at further to that, and the committee didn't note that, the doctrine of basic structure, the Supreme Court, again in the same jurisdiction, yeah, I think it was Justice Kana, he went over and even described what within a constitution is called basic structure. And basic structure of the Constitution, which cannot be amended, Mr. Speaker, and there's also the theory of unamendability, include areas like supremacy of the Constitution. You cannot collect signatures and go around the country and say that now you're passing an amendment to remove the supremacy of the Constitution. Number 2, the rule of law. Number 3, the principle of separation of powers. Number 4, the objects and principles of a Constitution. Number 5, judicial review, things like federalism, devolution. Those are basic structure things. Mr. Speaker, Kenyans coming together from wherever to say that they want more constituencies and to say where they want it does not in any way touch the basic structure of our Constitution and cannot therefore be stated to be unconstitutional, Mr. Speaker.
What's
Mr.
your
Speaker,
point of order, Senator Linturi?
Speaker, I rarely interrupt the senators when they are debating, and especially on such a critical, important bill that is before in the House. But Mr. Speaker, is it in order for Senator Sakaja to mislead this House, Mr. Speaker, that the Kenyan people, through the MBI initiative, went and made requests, recommendations, that they want extra constituencies, Mr. Speaker? When you look at the objects, the page on the memorandum and objects, the bill itself of the BBI bill says the issues that will inform constitutional change will be the views from the public. I want him to tell us which constituency, which county, who in particular, as a participant in the BBI processes, that proposed the 70 constituencies for addition. Mr. Speaker, whether the first bill that was introduced or report at Bomas, whether that report and any proposal on increase, Mr. Speaker, because that's misleading.
Chair, I will gladly do so. And I'd like Senator Bidika to listen carefully. Mr. Speaker, all if you look at Article 257, all the processes from the setting up of a BBI secretariat, to the gazetting of a task force, to meeting in Bomas, to meeting where not, going to Naivasha with MPs, are strangers to the process of popular initiative. Because, Mr. Speaker, the first document that is introduced in a popular initiative is a document that is gazetted by the promoters. The document that the promoters gazette in 257.4 and 257.5 that create a draft bill becomes the first document. There is no requirement in our law for a popular initiative, a promoter Kenyan, to conduct even any public participation before drafting a constitutional amendment. Mr. Speaker, I can decide with Ledama to draft a proposal to create 100 constituencies in Narok, so long as I get 1 million signatures. And after that 1 million signatures, thereafter, I go to 24 counties, and then public participation is done, I have the right. But I would like, Mr. Speaker, for anyone, and I challenge anyone, including my chair, senior counsel, anyone, because I've seen his movement.
I can see he's already...
Yes, I challenge anyone to show me...
He wants to intervene.
Chairman, I challenge, just let me finish kindly. Okay. I challenge anyone to show me where there is a legal requirement before the publishing of a draft bill by a promoter of a popular initiative to have conducted public participation, Chair.
Senator Mogeni.
Mr. Speaker, I rarely rise to raise points of order, but I cannot remain on my seat when Senator Sakaja wants to mislead the entire country. I want to refer my good friend, Senator of Nairobi, to the provisions of Article 10 of the Constitution, which has the national values and principles of governance. Mr. Speaker, if you read sub-article 2, it says the national values and principles of governance include A, patriotism, national unity, sharing, the rule of law, democracy, and I want to underline the last one, participation of the people. Participation of the people. Now, if you go to sub-article 1, and that's very important, Senator Sakaja, it says, the national values and principles of governance in this article bind all state organs, state officers, public officers, and I want to emphasize the last one, and all persons, whenever any of them, in sub-article 2, enacts, applies, interprets any law. That's very, very important. And then the other one, Mr. Speaker, is if you are implementing any public policy decisions, you must have public participation.
Chair, I'm very happy that, Speaker, I'm very happy the chair of the committee has not shown me any provision that demands for a sponsor of a public initiative before publishing the bill. Mr. Speaker, what is talking about the principles of national governance in Article 10? Once the draft bill has, you don't have to shout. Once the draft bill, Mr. Speaker, has been published, there is then, it is the mandate or the load or the burden to conduct public participation then rests with this institution. And that is why we did public participation.
Senator Cherargei, why are you being very nomadic? You are all over. Take your seat and... Okay, let's focus on what here.
Mr. Speaker, that is why we conducted public participation, county assemblies conducted public participation on a document presented by Kenyans. But to say that for the Kenyans, before they presented a document, to have conducted public participation, Mr. Speaker, any ordinary Kenyan can exercise their sovereignty in Article 1 and propose a popular initiative. Who is going to fund them to conduct participation? But once they've drafted a bill, or once they've given a general suggestion to the IEBC, then the institutions, once it's been published, are the ones mandated. So I think we're saying the same thing. It's not about before it is published. Mr. Speaker, allow me to just to go on, because because of time. I stated that the issue of basic structure, where you create what you call an amendability, the only part that you can prevent anybody from amending is what affects the basic structure of the Constitution, and that basic structure, Mr. Speaker, is defined, and there is precedence in that Supreme Court, Justice Khanna, Mr. Speaker, in Bharati versus State of Kerala, and he said that then those are the constitutive elements. Even if you collect 10 million signatures, and you go to all the counties and say we want to amend the Constitution to get rid of, this part of Kenya, you cannot amend the Constitution like that. It's not that everything can be changed. But, Mr. Speaker, my contention was that Article, the second schedule that we're trying to amend does not in any way, Mr. Speaker, change the basic structure of our Constitution. Mr. Speaker, secondly, in terms of the reasons, Mr. Speaker, secondly, I want to state that if you look at the current Constitution that we have, Section 27(3) and Section 4 of the 6th schedule of our current Constitution, Mr. Speaker, gives us a precedent. It was doing the same thing. If you look at the 6th schedule, Section 27(3) and 4 provided protection of existing constituencies under Article 89(4), meaning that even when IBC was going to do delimitation, there were constituencies that they were not going to touch. Mr. Speaker, what that means is that the provisions of Clause 74, read together with the second schedule, Mr. Speaker, is not a new idea. It has happened before. Mr. Speaker, thirdly, because if it was unconstitutional, if it was constitutional then, it should be unconstitutional. It should be constitutional now as well. It can't have been that it was okay then to say that there are certain 27 constituencies that no matter how you apply Article 89 can change, but now it is unconstitutional to say that out of the 70 we want them here. Mr. Speaker, and I repeat, any Kenyan, the people of Homa Bay County, can feel that they have been slighted. And they say, as Homa Bay County people, we want to add 5 constituencies to Homa Bay County. And they collect 1 million signatures. And they go to 24 county assemblies. We will not say that Homa Bay County people are usurping the role of IBC, because we've supported them as Kenyans. That yes, what they want is to amend the Constitution to create constituencies, 5 more, and they've decided where they want the 5. And in that same breath, Kenyans had the right to say we want 70 new constituencies, and this is where we want those 70 constituencies, Mr. Speaker. Mr. Speaker, I have heard members saying as well that delimitation is the work of IBC and no one else can do it. Mr. Speaker, I want to state as follows. The provision of 70 new constituencies is not delimitation. Delimitation is defined even if you go to the Black's Law Dictionary. Delimitation, Mr. Speaker, is defined, if you go to the Africa Union Border Program, they've said that delimitation and demarcation are taken together to emphasize the close relationship, and they're not interchangeable. Delimitation is a term applicable to describing a boundary line and a limit of an electoral area. Of the 70 constituencies, Nairobi gets 12. IBC will determine where those 12 will be. They will say Kasarani, which has 397,000 people, can be divided into 2. They will go to another county and say, we have said there will be 5. The actual delimitation, using the formula in Article 89, of 40% and 30%, will be applied by IEBC. But allocation is the same thing that we did in the last Constitution to say that this is the exact number that you want in addition.
There's a point of order from Senator Wetangula.
Mr. Speaker, I beseech you to also hold my time, because there have been almost 20 points of order, Mr. Speaker. And I'm not even going halfway.
Mr. Speaker, is it in order for my distinguished nephew, the Senator for Nairobi, to cloud his argument with sectarian interests and mislead the House on what delimitation means? Delimitation of boundaries of constituencies and wards. First, it is vested in IEBC. Secondly, it is exercised after IEBC has listened to all Kenyans in every county, in every constituency. Nobody can sit in a room somewhere and create constituencies and say where they will be, and then hand over to IEBC and say, now you can delimit. It must be an equitable process involving each and every constituency, ward, and county in the country.
Chair, of course, I disagree with that. And it's not a sectarian view. I was going to give even Bungoma. Mr. Speaker, the word delimitation is not based on anyone's opinion. It is an English word. It is a word used in geospatial, science. It is a scientific word. If you check even legally, if you go to Black's Law Dictionary and Google delimitation, it is not based on my opinion. Delimitation is allocating and specifying where exact boundaries are going to be. Our problem is in the allocation and where those allocations have been made, Mr. Speaker. And that's the problem that the members have. Mr. Speaker, and my point is this. The problem, and Mr. Speaker, surely.
Proceed, I'll give you at some point.
Okay. Mr. Speaker, the point I'm making is that the actual delimitation, where you will go, you will listen to people, you will hear the arguments, even when in the last constitution, we said that 29 constituents, just even you can be allowing me to finish a sentence before the point of order.
There's a point of order from Leader of Minority.
Mr. Speaker, you know, the judges normally look at people who are using what they call judicial craft. You become crafty and you try to make a word meaning what it is not. If you read the Constitution has got its own language. So if you want to know what delimitation is, you don't go to the Black's Laws Dictionary. That's just a tool of interpretation. The first document you go to is the Constitution. And the Constitution says what delimitation involves. And when delimitation is carried out, what it is done, how it is done. So this cloudy thing that you're looking for is very fanciful and very attractive. But if you want to know what delimitation is, if you read it in the context of the Constitution, it is very clear. And I hope, Senator Sakaja, you can listen to your older brother there, because he's been in, uncle. He has been in this business a little longer. He has done cases in court which involve the question of delimitation. In fact, if you want to review the powers of the IEBC under Article 89, normally you find a lot of case law and jurisprudence on what is delimitation. So it is not a fanciful word that you got to go to the Oxford Dictionary. In fact, in the Oxford Dictionary, you can find a meaning of a Swahili word. This Oxford is so wide these days. And the Anglo-Saxon English is very different from American English. The spellings are different. So I think you should just declare that you're in a good place as far as Nairobi is concerned.
There is another point of order, Senator Sakaja. Just hold on. I'll give you'll
give me more time, Chair.
Yeah, Senator Cherargei. First, then.
Mr. Speaker, I agree with the minority leader, because when you look under Article 88(4)(c), the delimitation of constituencies, and when you know the language of the Constitution, Mr. Speaker, when you look at Article 259, construing of this Constitution, 259(3), every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking, and therefore among many things. So the interpretation of the Constitution, according to my professor Mutaha Kangu, who taught me the constitutional law then, is that the Constitution should be interpreted in the language, and it is speaking. It is alive both in spirit and substance. So the way Senator Sakaja, Mr. Speaker, is trying to put across is that the interpretation
Senator
of the ordinary
Kajwang,
English.
Let's have some order up there. I don't know.
I think...
you are behaving in a very suspicious manner behind there. Yes, Senator Cherargei.
So, Mr. Speaker, as I conclude, is that, so there is the language of the Constitution. So I would advise Senator Sakaja to avoid being intellectually dishonest or legally crafty by introducing things that do not exist. Thank you, Mr. Speaker.
Senator Kimani Wamatangi, there's another. Then Senator Cheriot.
Mr. Speaker, I wanted to raise my point of order when Senator Wetangula was just on the floor, Mr. Speaker, but then I was also followed by the minority leader. but Mr. Speaker, and I raise that point of order because I virtually agree with what Senator Sakaja is saying. And my point of order, Mr. Speaker, is derived from exactly that article of the Constitution, Mr. Speaker, because the point Senator Sakaja is making is very simple, Mr. Speaker, that it is provided as to how it would arise that the creation of a constituency will occur. And that is in the quest and exercise of the responsibility of IEBC to ensure that there is compliance with the population quota. Exactly. And Mr. Speaker, in compliance with that population quota, the argument he makes is very simple, that quota of that population can only be domiciled in a certain region or certain area. Call it a constituency. And if then it is found that the population of that area does not conform to the requirement of that quota, then a constituency will be created within that region. So if it was within Nairobi, Mr. Speaker, for example, in Nairobi Central Business District, and IEBC finds that as required by the Constitution, that the population quota is not complied with, then they will have to propose the creation of a constituency, of course, using the right means.
So what's your point of order?
Mr. Speaker, my point of order is very simple.
Yeah.
That Senator Sakaja is right to the extent that Senator Wetangula and the minority leader, with due respect, are wrong, because the creation of that constituency would have to be within the area that is non-compliant. And so you cannot create a constituency in Nairobi and transfer it to Bungoma.
Okay.
Mr. Speaker, it has to be within the place where it is created.
Okay.
And thus, in that process, Mr. Speaker, when it is complied with, that is even how now in the second schedule,
okay,
you find that those constituencies are within the areas that are non-compliant with the population quota.
Okay. Senator Cheruiyot.
Mr. Speaker, there's something Senator Wamatangi doesn't get. He made this mistake in the morning. He keeps on repeating it. And yesterday, this is the point, Mr. Speaker. Just listen, Senator Wamatangi. You see, the debate is not about where the constituencies are placed or where they will exist. The debate, listen, just listen, Senator Wamatangi.
Order, senators.
You know, since he became a whip, Senator Wamatangi listens to no one anymore.
Order.
I want to remind him there have been previous occupants of that office, and they were very powerful. So, and there could be others.
Order.
So,
okay, proceed, Senator.
Please keep your cool, just like we kept quiet when you're speaking. This is the point. Whether it is possible in a constitutional amendment bill, you domicile a number of constituencies and limit IBC that these constituencies can only exist in a particular area. And that is why we were asking earlier on, Mr. Speaker, what is the interpretation of people like him and Senator Sakaja of Article 8910? This point that Senator James Orengo keeps on repeating, that if anyone was to appeal this it can only be after the commission is done and satisfied with the delimitation of boundaries. Therefore, no, that means you agree with us in our school of thought, other than, Senator Sakaja. And this is a point that Moses Wetangula was making.
Address the Speaker. I can see you might throw the Constitution at
No, I can't. Mr. Speaker, I'm a gentleman.
I could see you moving.
No.
Movement.
I am a gentleman. You know, Mr. Speaker, in linguistics, there's something they call, and they teach this at the university, English for specific purpose. That not every word means the same thing in different fields. I can give you an example, Mr. Speaker. If you take a phrasal verb, like to know someone, in basic English, it means that I know you as Ken Lusaka. But in religious English, to know someone means something else. It means to procreate with them. So you cannot take the elimination of boundaries the same way they want to interpret it, that it is a work of IBC. That is not what this constitution intended. That is why they have provided it in subsection 10 of 89, that you will only appeal after it is done. If you domicile it in a particular county, what is a work of IBC?
Okay, there's a last one, Senator Sakaja, from Senator Harugura.
Thank you, Mr. Speaker. I'd like to raise on a point of order because I'd like to know whether Senator Sakaja is in order, insisting that while it's very clear that we are not disputing that either by popular or parliamentary initiative, the number of constituencies can be increased. But the issue is to locate them, because the Constitution talks of even the population quota, that is the work of IEBC. But if already you have a schedule which has already allocated them, then what will be the work of IEBC after that?
Okay, Senator Sakaja.
Thank you, Chair. You know, if members listened for the logical conclusion of an argument, even what Senator Cheriot is asking and Senator Arguria is asking will not be a question. So, Chair, our standing orders are clear, Speaker. When someone rises on a point of order, let them say what is out of order, because all we've had is points of argument. Despite all the poetry we've had about delimitation, no one has given us a contrary definition, because that is the definition that is there. Allocation of constituencies is one thing. Delimitation is deciding exactly where in that area it is, Mr. Speaker. And Mr. Speaker, when that process is being done, because in the same way, Senator Argura, that you're saying it must be done by population quota, in this constitution we have, the schedule spoke about 27 constituencies which fell below the population quota and said those 27 will not be touched. That was a schedule. The schedule is part of the bill. The schedule is not an inferior part of the bill, Mr. Speaker. And that schedule became part of the constitution today. So in the same way, and Senator Aaron is asking, that why is it that we can say, that Kenyans can say, we want 70 more constituencies and say where they are. If that is unconstitutional, then what you're saying as well is that Senator Ongeri's people, having passed the threshold required in the Constitution, cannot do a popular initiative to ask for one more constituency in Kisii, because they'll have asked for constituencies to be increased by a certain number and where they should be put. Mr. Speaker, on that one I disagree. Even if I am alone, I disagree. We cannot usurp the role of the people. The people themselves can bring an amendment here to do away with IEBC. IEBC is a creature of the Constitution. In fact, the people can bring an amendment to do away with the Senate, Mr. Speaker. So what the people have proposed here to increase constituencies is within their right. And final say will be with the people of Kenya at the referendum. They will decide whether they agree with it or not. Tomorrow, Makweni can bring the same proposal. So, Mr. Speaker, that is my point. And the points of order are points of argument. We do not have to agree. We shall express it at the referendum. Mr. Speaker, as I go ahead, we don't have to agree. Mr. Speaker, some of the imbalances,
Okay. Who is the point of order?
Surely.
Senator Orengo.
Mr. Speaker, I want to say that I support this bill, and that's what I said. But it's always wrong to make factual misstatements. In fact, in the courts here, if you go and argue today that this is what the law says, and you appear before the court the next day and argue the opposite direction, you will be put to order, or you may be cited. Mr. Speaker, there's a problem that we're having persistently when people think that if you have a bill to amend the Constitution through the popular initiative, then it is by the people. It is not by the people. It is by the promoters. And promoter can be one person. All he needs is to get 1 million people. If it was the people, we need the whole of Kenyans to sign. This is a bill brought by the promoters. It is not by the 1 million people. The 1 million people was a condition precedent before you can take the bill to IEBC. So I think you should think of the process. The process is what is popular initiative. It's not that it is by the people. It is a popular initiative because you go through certain thresholds. Yeah, so I think we've got to be very careful about what you're saying.
Chair, there's a difference between a popular initiative and a parliamentary initiative in terms of who originated, the thresholds. A parliamentary initiative does not need a threshold of 1 million signatures before it comes to this House. It does not need 24 counties. The reason why there's a higher threshold, and that's why I've given the precedent, I've quoted the case law in India. I've quoted that it is the people who ultimately make the decision at the referendum. So if the people agree that those 5 be added to Siaya, or that 2 be added in Nandi, or that 12 be added in Nairobi, it is so. It cannot be unconstitutional, Mr. Speaker. It cannot. There I disagree. But Chair, if you allow me to go on, because clearly there's no point of order there. At all. There's no point of order. Mr. Speaker, I want to raise the issue further within the... No, Mr. Speaker, the process of delimitation, once the numbers have been passed, for instance, Mr. Speaker, because I know BBI will pass. When BBI passes, Mr. Speaker, there will be 360 constituencies. These 360 have been defined in terms of where they will be. I think there are a few in Kilifi, there are some in Siaya, there are some in Kiambu, etc. Mr. Speaker, those in Kiambu, for instance, or those in Muranga, or those in Uasin Gishu, the authority to determine the boundaries, the population quota, where this constituency will start and where it will end, is the role of the IEBC, and this BBI has not touched that role. So, Mr. Speaker, I hold that is constitutional. Mr. Speaker, further, I don't seek to be informed, Senator Wetangula. Mr. Speaker, further, in view of the
order, senators. Order.
Chair, because of time, I'll accept information a bit later, because you're stopping my flow.
Senator Sakaja, Senator Wetangula is even invoking a relationship for you to listen to this information.
Chair, you know the problem.
I ask you to...
I ask you, Mr. Speaker, because many times you interrupt me even in the middle of a sentence. Can you just allow, even for flow, for me to finish a paragraph and then let him come in? And I would never refuse information from my distinguished uncle, but I just want him to hear this part, Mr. Speaker, because somebody has asked about public participation. Mr. Speaker, in proposed amendment by popular initiative, the burden to conduct public participation required by Article 89.7 in the review of boundaries, because that is when then you have the Constitution, does not fall on the promoters. Let's not call them the people then. Let's call them the promoters. It does not fall on the promoters. The burden to conduct public participation will then fall on IEBC in Article 89.10, as Senator Aaron Cheriot, once those numbers have been created, Mr. Speaker. Mr. Speaker, as I've said, a schedule is part of the bill, and in this case, the same rules would apply to consideration of the main body as applies to the schedule. Mr. Speaker, again, we have had people raising concerns on where these constituencies are going. Mr. Speaker, the point which I want my distinguished uncle to hear, and Senator of Siaya, the issue of fairness should not be mistaken for the issue of constitutionality. The issue of fairness, of why this county has gotten and why this county has not been allocated, is not the same issue as the issue of constitutionality, because that one is debatable. When the KNBS came to us, Mr. Speaker, because, okay, let me take the information.
Mr. Speaker, my distinguished nephew, the Senator for Nairobi, is making very cogent but faulty arguments. Extremely faulty. Mr. Speaker, the issue I want to inform my distinguished nephew, the Senator for Nairobi, is this: that in delimiting and creating additional constituencies, whether the people of Marsabit qualify or not, whether the people of Mandera qualify or not, whether the people of Kitui qualify or not, the underlying principle and philosophy in this constitution is equity and fairness. Article 10. And you can find that in Article 10, that you'll end up giving Nairobi the constituencies, but here Marsabit, here Mandera, here others. What is even more important, Mr. Speaker, and that's why his arguments are faulty, even for us who support this constitution amendment, is that when you look at Article 89, I don't mind the information before I finish. Yes, you can inform the
Okay, no. Order, Senator. Order. Order.
you know, Mr. Speaker, In law, we have a doctrine called watching the watchers. And we can also have informing the informers. This is the growth in law and in debate. But I want to inform my distinguished nephew, Mr. Speaker, that when you look at Article 89, the delimitation of boundaries of constituencies, you have to take into account, for example, 89.5, geographical features and urban centers, community of interest, historical, economic, and cultural ties, means of communication, all this. Can you show us from your report, since you are in the committee, where these requirements were met before the 70 constituencies were fixed in the amendment? Because, don't be too agitated, my nephew. You know, there's a doctrine in English called being clever by half. It's very dangerous. I'm sorry, my nephew, I retract that. But the hyena told a stone, hata usiponijibu, umesikia. Mr. Speaker, my distinguished nephew must know that we know what he's saying, defending the constituencies given to Nairobi. He's taking a long cut. You can actually take a shortcut and say you support what is given to Nairobi and let others debate these issues.
Chair, Senator Wetangula is grossly out of order to impute improper motive of my intentions. Chair, if there's a member in this house who sacrificed for other counties, and you know it, on what counties are getting, it has been me, even in the revenue formula. And I've been very clear. When Nairobi was getting 100 million, I stood with 18 counties. It's not about what Nairobi is getting. Mr. Speaker, on allocation of resources, I have the T-shirt, I can wear the T-shirt. But Mr. Speaker, allow me to go on. Mr. Speaker, on equality of the vote.
I'm going to allow you, Senator Sakaja, but avoid situations that will attract so many points of order. Because you are attracting these things yourselves.
Okay,
and
Chair.
when they ask, I cannot deny them.
Okay, Chair, let me say this.
Proceed.
Chair,
yeah.
I'm making my point.
Okay.
Because, Mr. Speaker, I have a track record in this house. This house has answered. This house is a house of records. Senator of Kilifi, I stood with you and Kilifi was losing. It's not about who's gaining. On allocation of resources and equity, I am clear. But allocation of constituent equality of the vote, a principle in Article 21 of the Universal Declaration of Human Rights. And in our constitution, I am clear that equality of the vote is even in our constitution, we talk about 30% and 40%. I'll ask the lawyers who are senior here. Look at Kacha versus Daggett in the US Supreme Court. A deviation of 0.7% was found to be too much, Mr. Speaker. And Mr. Speaker, another point of information, because I can see Senator Wetangula going to Article 89. Again, consult the answer of this very house. In 2009, 2010, when this constitution was being written, I dictated the whole of Article 89 that we have in this constitution. So I understand it. So the question that you have asked, it is a record of this house. So the question that you're asking, Mr. Speaker, on how geography will be taken into account, on how community of interest will be taken into account, of how all the factors there, that then is the work of the IBC when they are drawing the actual boundaries. Mr. Speaker, as I go to conclude, Mr. Speaker. Mr. Speaker, the cardinal point of imbalances, because you're talking about imbalances, I will show you imbalances. Mr. Speaker, the principle of equality of the vote is that because not all Kenyans can come to parliament, Kenyans need to be in as equal as possible constituencies to give one representative. Mr. Speaker, today, the people of Kasarani, for instance, and I'll use Nairobi as an example, have 398,000 with one member of parliament. While the people of, for instance, Isiolo South are 77,000. Both have one vote, Mr. Speaker. The people of Elgeyo Marakwet as a county is 444,000. Nairobi is 4.3 million. Yet we're talking about representation of the people. Mr. Speaker, on that one, the right of the people to be equally represented. And Mr. Speaker, the issue in our country is that we mix two things.
Order, Senator.
We mix allocation of resources and representation of the people.
Okay,
allocation of resources is about equity and services.
There's a point of order from Senator Abshiro.
Is the honourable member in order to use the same things that had been protected by the same Constitution and the same Constitution Amendment Bill 2020 to then argue and counter-argue, then it makes null and void the argument that the constituencies were required in the first place. What about then using the same arguments? What happens to the fact that the argument is that the ones that have been protected by the same amendment bill?
Yeah, the point is this. This BBI, because of the, it's not up, Senator Pareno, because of the constituencies that fall below the population quota, all of them are protected. But because you protected a constituency that is below the population quota, does not mean we deny a constituency that requires proper representation, Mr. Speaker. That is the point, and that principle is enshrined in our constitution. So, Mr. Speaker, I hold that assertion by the committee that the schedule is unconstitutional is completely wrong. Mr. Speaker, the question of fairness, for instance, Kisii, 1.2 million people, has been given 9 constituencies. Ideally, they should have 10. Mr. Speaker, Kitui ideally should have 9. But the reason why you're seeing some fringe ones are not getting one more is because, Mr. Speaker, of the ones which are protected. In fact, in the same proposal, Mr. Speaker, in the same proposal, Nairobi, where people are complaining because Nairobi is getting 12, is supposed to get 16. That is what KNBS told us. So even the 12 you're getting extra, it should have been 16. Kiambu, yes. I don't know what Kagame is getting. Bungoma has 9. Bungoma has gotten 3 constituencies to come to 12, yet ideally, Bungoma should have 13. Do you know why you don't have the 13? Because Lamu County, which has 2, should have 1, if you look at that formula. But we're protecting the 2 in Lamu. So, Mr. Speaker, equity is give and take. For that reason, Mr. Speaker, I support the BBI, but I will forever stand to support equal representation for my people in Nairobi and of all.
Your time is up.
Who deserve fair representation, Mr. Speaker? I submit.
Senator Zani. Senator Zani. I can see a point of order before you even start. Senator Wamatangi.
Mr. Speaker, I had earlier on requested that I rise on a point of order, Mr. Speaker, because this is a House of Records. And Mr. Speaker, when I walked in, the senator for Kitui, Senator Wambua, was on the floor, Mr. Speaker, and he put it emphatically on record that as far as this schedule 2, second schedule is concerned, Mr. Speaker, that Mount Kenya region is receiving, has been allocated 40 constituencies. Mr. Speaker, that is faulty, wrong, and misleading in the records of this House, Mr. Speaker. The counties that have been allocated constituencies in the Mount Kenya region are here in this schedule, Mr. Speaker. And I want to correct, Mr. Speaker.
Order, Senator.
Mr. Speaker.
Order, Senator.
It has been put on the record of this House. Something that is erroneous and wrong and untrue.
Okay. Senator, okay.
Of Mount Kenya region are not receiving 40. Indeed, we are receiving only 17. They're here, Mr.
Okay,
Speaker.
Senator Wetangula. What's your point of order? Senator Kangata, this is not a market. You are just roaming out of a sit down. Senator Kangata.
Mr. Speaker,
yes.
I want to beseech the chair that this is the Bible.
The Senate is one of the institutions that has really suffered to the point that, for example, even in terms of oversight, we've not been able to do proper oversight because we cannot have the CS come into the House. And yet that is important. And we're seeing the introduction of this now through the amendments. And then also fortify our national ethos. Statutory enactments and institutional reforms becomes very, very key and very, very important. So throughout, in terms of policy, administration, these are all put together in this bill, Madam Speaker. And there are key amendments that have been made at various levels, and these have been well articulated both in the bill and also within the report. Though we said we're not debating the report, but we've read it, and that is also captured there. So the amendments right through chapter 2, 3, 4, 6, 7, 8, 9, and 10, and especially at 11. The allocation increase of 15% to 35%, I think, is very, very clear and very, very important. And of the last audited accounts, makes it possible for these funds to be delivered prompto. The also issue of Ward Development Fund is very, very critical. And then also in the specific schedules that have been put there, and they have been amended, I think also is very, very important. I just want to touch on a few of the amendments that have been made. The Controller of Budget Act number 26 of 2017, which allows money to be checked before releasing more funds to specific counties. And Madam Speaker, you will remember that most of the time in the Senate, this has really become an issue because our oversight ability has not been able to help us capture how funds are used within the counties. And then we keep having a problem that the Controller of Budget has released more funds. We hope that this particular amendment allows now counties to be accountable to themselves because they know they will not be able to get more funds. On the higher education loans, one very critical amendment is that the loanees now will have a grace period of 4 years. And Madam Speaker, having come from a university background, we know, and also just generally being a Kenyan, we know the problems that students have had, especially when they don't have jobs. And yet, even without a source of income, they're expected to pay up. So this, I think, will release some pressure from them. The prompt payment bill, I think, is a bill from the Senate through Senator Faria, and the prompt payment of services and goods that have been procured.
Langat, sorry, there is a point of order from Senator Langat. I don't know whether it has to do with this presentation. Virtual, Senator Langat. Senator Langat. Okay, let's continue.
Thank you. I will continue. Then we have the County Wards Development Bill, which has been very exciting. This came at different points through different bills. I think at one time, Senator Kangata was dealing with this as well. But now this is also now entrenched. We have the Ward Development Fund, which will help. Anti-corruption and economic crimes, for those who have been dealing with the issues of penology and crime generally, we know these are the areas where a lot of people are able to escape penalties because of economic crime. So those who end up paying the price and end up being punished for maybe social and cultural crimes rather than economic crimes. And then we have the Public Participation Bill. Unfortunately, Madam Speaker, this is a bill that we started right through, I think, 2013, 2014. This has not come through up to now. So this bill that really provides an effective framework for effective public participation is very, very key. We also have the Persons with Disability Act number 14 of 2013, which will be able to reflect the rights declared under Article 54 of the Constitution, and very, very critical for people living with disabilities, PWDs. So through all this, of course, we have the draft bill that we are now debating, and really at the end of the day, we understand that this is through a proper, popular initiative that has specific stages to follow from Article 257. And even though Article 257 is silent on public participation per se, and the members of the Joint Committee also clarified this very well. They said that these values are entrenched in Article 10 and in Article 118. I think this is what Senator Omugeni was earlier saying on. So taking it through public participation and getting these various views are very, very important and very, very key for us. To the issue whether the bill needed to be published, and this has been well argued in different forums, we said that the bill is sui generis because the counties already debated this bill and now it has come to the floor of the House. Madam Speaker, very quickly, some of the issues that are very, very critical is issues like, for example, the increase of percentage from 15 to 35, the issues that the bill is very, very critical and it will be subjected to a referendum. The issue that parliaments will and have participated in this process, and the value of input also that has been put at the various times. Madam Speaker, one of the issues that has raised a lot of contention, and this happened in the afternoon, is the proposed 70 additional constituencies. But the basis of this has been and is reported to be from a report from the IEBC themselves on the revised preliminary report of the proposed boundaries and constituencies and wards published in 2012. And many of these counties are the ones that have been incorporated. But again, a lot of insights and discussion is coming in terms of how these 70 additional constituencies should actually be allocated, how they should be delimited. And I think all these are healthy because in the long run then, we need to be able to ensure at the end of it all that equitable resource allocation can be adhered for all the particular counties. And the population data needs to be put into consideration for us to be able to do that. The framework for compliance of the two-thirds gender principle, this is very key. Already in the Senate, we will have not only two-thirds, we will be at 50%, but in the National Assembly, arguments as well have been put in terms of, especially if the women rep is not there as a position, what will happen to the GAF money that they had and the role that that money played in the development that they did at various levels. Another important component of the bill is that the removal of vetting of the PSs, so that now they don't feel that they have to be necessarily tied up with the politics of the day. They've been left free so that they don't have to be vetted. So we have also the implication of the proposed amendment on Article 203 on prioritization of per capita allocation and capping. These become very, very key because especially when it comes to the resource allocation and how that money is meant to be distributed across the board, it becomes very, very important. Madam Speaker, some issues have come that are really just technical issues. And from Senator Mugeni's report, for example, that certain clauses mix-up has happened within the report. I think it's going to be very critical and a way has to be found within the Senate to be able to identify, for example, in clause 13B, the clause 3 does not exist. The clause that is referred to is clause 2, and this is from the National Assembly. At the same time, also, from the Senate draft, we are referring to 87.7, whereas it should be 89.7. I think these are basic issues that probably need to be looked into. But I think also from Senator Sakaja's input that the substantive issues need to be taken into consideration and left in place across the board. Because again, these substantive issues are very, very critical and they've been well put out. Madam Speaker, I think over time, a moment like this has been awaited for in this country, and this moment has come for us. I think it is good that we're having these discussions, we're able to put both the pros and the cons, but at the end of the day, we should not lose the motion and the direction for the amendments that are being made in this bill, so that we can have the issues that needed to be addressed. I thank you, Madam Speaker.
Thank you, Senator. We'll take one online, Senator Christopher Langat. Senator Christopher Langat?
Yes, do you hear me?
Yes.
But I want to begin with what Senator Sani has highlighted. And I want to say, before I read this particular constitutional amendment bill very critically, I was also very to do with the loans, help loans, and the matters to do with what we call holiday, tax holidays. But after reading critically, I realized that these are sweeteners that were meant to actually attract the attention and persuade the youths so that they can join their hands in actually getting convinced that these are very wonderful documents that will transform their lives. But if you find out, Madam Speaker, you'll find out that the students who are in university and those who have completed university in this country and those who have been employed, that they can enjoy these particular privileges are very few vis-a-vis the number of youths that are suffering in this particular country. I would have expected a robust structure that will help a greater percentage.
Senator Langat, we are losing you. Senator Langat, we cannot hear you.
With inclusivity, the 42 tribes, though they are fairly included in sharing the resources of this country through devolution, I want to say that at the top of the executive, this particular bill has not represented the 42 tribes effectively as included 42 tribes, especially the smaller tribes effectively. These 5 positions that have been created, or 6, are only intended to convince the bigger tribes so that they can get into a political coalition to continue what has been happening, that we merge the big tribes to swallow the smaller tribes, and then the big tribes take advantage in leadership of those particular smaller tribes. So I'm yet to be persuaded on the core object of this particular bill, which was actually inclusivity. This inclusivity to me has not been taken as the Kenyans were expecting. Number 3, Madam Speaker, is that when I hear of the differences in the bills, be it grammatical differences, be it content differences, whatever they may be between the bill in the National Assembly and this one, I'm also more or less convinced that, therefore, the bills that went to the county assemblies or the drafts that went to the county assemblies might have been having more differences than what we are seeing. And even maybe the drafts that the common citizens were given have also more differences. So when we are dealing with a serious constitution, which will guide the framework of the development, sharing resources, and creating peace and harmony in our country, these particular small errors and differences should not even should not involve any advancements of this particular document. Another one is that every constitution, Madam Speaker, all over the world, I've seen even during the time of Ronald Reagan, he emphasized on actually bills that were aimed at the reduction of government expenditure. In this particular bill, it creates more burden to the taxpayers, simply because it is not enough to say there will be a prime minister. It's not enough to say that ministers, deputy prime ministers will be there. We should also be concerned with a lot of resources accompanied to those particular offices. So I want to say that at this point of time in our country, where the other time we had to open the ceiling so that we may continue borrowing, who will allow us to continue borrowing for the sake of creating position. So I want to say this particular bill overburdens the taxpayers, and actually it should not be given the light of the day. If you check critically, Madam Speaker, all those things that we talk about, that they are good, to me are sweeteners that were aimed at making some people, youths and some communities, to swallow this particular bill with a little bit ease. I want to say also, any amendment that is retrogressive on matters to do with justice, touching on judiciary, a very important organ in this particular era, reducing it back to the point that we are now allowing the executive to introduce the ombudsman, that is usurping the powers of this constitution, and especially the separation of powers, and particularly reducing the strength of judiciary. So this one again is an issue that we've got to tackle it seriously, Madam Speaker. Another one that I want to mention, I don't want to believe to belabor so much what people have talked about. I'm concerned with the office of the Prime Minister. The appointees of the Prime Minister are the same people who can start or implement an impeachment. This is a very important point, Madam Speaker, such that those powers of impeachment should end up in the Senate, which is not among the appointing authorities, so that this particular Prime Minister may get some immunity. Otherwise, if we allow the Prime Minister to be appointed by the President, approved by the National Assembly, and those are the people who can still impeach the same person, they will control that particular office. They will impeach the same person in whatever time they want, the way the MCAs are doing right now in the county assemblies. And if it was not for the Senate sometimes to be balancing the impeachments of the county assemblies based on some of their greedy needs, I am telling this particular house that the office of the governors would not be what it is up to this particular time. So this particular office of the Prime Minister, we must look.
Can you hear us, Senator Langat? Yes, Senator Langat, can you hear us? Yes, Senator Langat. Now he's gone. Now he has gone completely. Senator Langat, we need to see your face. According to our regulations, we must see your face. We thought it was our camera. We have checked our cameras. We are perfect on this side. Please go to a place we can see you so we can give you your 5 minutes to speak. The balance 5 minutes we'll give you only when we can see you. Senator Inima Ketrut Musuruve. Senator Ladama, you are correct. But this time I have used standing order number 1 very correctly. Absolutely. Yes. And yes, I did consider some factor. So I'm going to take you next. Thank you.
Thank you, Honorable Speaker, for giving me this opportunity to give my comments and thoughts about the Constitutional Amendment Bill of 2020. And Honorable Speaker, I want to begin by thanking Senator Omogeni and his team for coming up with the report and giving us information. And indeed, information is power, information is good. However, Honorable Speaker, I want to say that there are diverse and divergent views about this bill, but I want to say that overall, there are enormous gains that we cannot just wish away. There are enormous gains that we must speak to so that people can also know the goods about the bill. Honorable Speaker, I want to say that some amendments of this bill come out strongly to support the gender issue and close the gender gap. When we look at clause 7,
Clause 7 of the bill that seeks to amend Article 82F. Now, in Article 82F, the new word that has been inserted, sanctioning political parties that actually do not comply with the two-third gender rule, is a plus for the women in this country, because political parties will ensure that in as much as they are nominating people for elected positions, women are also actually elected. And this sanction, it mandates, it obligates political parties to do nothing other than ensuring that they're actually implementing the two-third gender rules. Honorable Speaker, I want to say also that I note very clearly that Clause 13 of the bill is also amended that speaks on issues of disability. And as a PWD representative, I want to say before the floor of this House that this amendment is a plus for people with disabilities in this country. And why am I saying this? It is because in the Senate, we have two representatives for persons with disabilities. We have, a male and female, like in this contemporary case, Senator Mwaura and myself represent persons with disabilities. But now this amendment is again for persons with disabilities because they have now been shifted from the Senate, they've been taken to the National Assembly. And in the National Assembly, the number has been doubled, 2 women, 2 men. Actually, it would be mean for me not to acknowledge this gain that has been given to persons with disabilities. And apart from that, this is a guaranteed position, Honorable Speaker. It is a guaranteed slot that we are not going to say that maybe they'll be there or maybe they'll not be there. It is factual. It is actually inherently there. So this is something that I must support because we'll have representation at the political level. And Honorable Speaker, most of the time persons with disabilities have complained out there, and they're still complaining that when it comes to leadership, when it comes to political representation, they are underrepresented. But this will be a time, this will be a chance for the representation of PWDs to be higher, and the voice will also be greater, Honorable Speaker. Honorable Speaker, I also want to say that the amendment, the clause that amends Article 98 also concerning representation in the Senate. We have 94 senators that are being proposed in the bill. And in the 94 senators, we have also women being represented there on a 50-50 ratio. And this is not a mean, amendment. It is again for the women fraternity, because women will have an equal share of voting just like their male counterparts. And Honorable Speaker, and it is a reality that in this House, many at times nominated women are discriminated upon, and sometimes when there is a need to vote, you find that if it's one representation per county, nominated members go through harrowing moments. And it is very clear just some time back when a letter was written to bar me and Senator Shionga from making a vote. But I want to say that this bill comes to strengthen the women who will be here, because they'll have an equal vote as well as the men vote. And I want to speak also about the issue that is being talked about the women funds and all that, the gains. Those gains can be relooked at. But the women who come here, they'll stand an equal chance of getting the same amount of money that their male counterparts are getting. And that is a big gain. And we should not actually, go to trivial issues and say that women have really worked for, the money, they get money and all that. It can be then taken to the National Assembly so that there is a mechanism of ensuring that the women in the National Assembly get the funds. But the women who will be here will be at par with their male counterparts, will get the money that their male counterparts are getting, and they'll vote on an equal basis. And that is a plus for the women of Kenya. Honorable Speaker, I'm also happy that even that representation of 50-50 then entails that the issue of delegation will not be there. Everyone will be here with his or her own right and vote in his or her own right. And I want to say, Honorable Speaker, that it is again that we cannot wish away. Honorable Speaker, I also want to look at Clause 22. Now, Clause 22 amends Article 131 of the Constitution. Now, when we look at the expanded, expanded executive, now among the functions of the president every year is supposed to really make a speech, an annual speech. And the president will talk about many issues that are happening and all that, from national, international, and all that. But in the Constitution, he did not have, the present Constitution, he is not mandated to talk about socio-economic rights, which is very important. When you're talking about Article 43, Article 43 of the Constitution talks about socio-economic rights. We are talking about issues of water. We are talking about issues of health. We are talking about issues of, basic needs. And I want to say that basic needs are very important, Honorable Speaker. If you do not have your basic needs, even on the hierarchy, Maslow, the psychologist, stated very well, you cannot aspire to go to the other level of needs if your basic needs have not been addressed. But, Honorable Speaker, the present Constitution we are talking about, the amendment, will ensure that the president is standing before the nation and saying what exactly he has done, what the country has achieved with regards to water, with regards to housing, with regards to infrastructure, with regards to also, health. And these are issues that affect each and every family, Honorable Speaker. And I think it is a plus for the president to also tell the nation the improvements that are being made, how many, hospitals have been made. That will ensure also even it cascades to the county government, so that county executives come and say before everyone else what they have done in their docket with regard to socio-economic needs and socio-economic rights, because there are rights that affect women, there are rights that affect children, and if we are to break the cyclic nature of poverty in this country, and I want to say that women and children are among the poorest, nationally and internationally, the president needs to say and even give us a platform of really what he wants to do with regard to addressing these issues. And these are fundamental issues, and I think on this strength, I think that it is a good point that Kenyans must know very well that when the president addresses these issues, then many hospitals will come up, more funds will be taken to health, more funds will be taken to education, and water must be provided. And not only water, but clean water, because it is a constitutional requirement, Honorable Speaker. Honorable Speaker, still on this amendment that talks, that seeks, this clause 22, that seeks to actually amend Article 130. It talks about the expanded executive. As Kenyans, we must be alive to the fact that what has really been ailing Kenyans in most elections has been the winner takes it all. Because after every election, you will find the winner takes it all, and the number two has no space at all politically. Number two is just stranded. Number three is stranded. But the expanded executive now gives an opportunity for the face of Kenya to be seen in the political arena. Because in the expanded executive, yes, we'll have the president at the top. Yes, we'll have the president at the top. We'll have the vice president at the top, following. We'll also have the prime minister and the two deputy prime ministers. And we'll also have, not the CS. We now have the cabinet ministers Yeah? So this is a plus, because the face of Kenya will be there. If your president and number two even number two has followers. Number two has value addition in this country. So the one who comes number two will still have value addition in this country. When someone is a loser, it does not mean that the person does not have followers. It does not mean that the person doesn't have value addition in this country. And I want to say that this will also help bring the curve down of the many, post-election violences that have always been going on in Kenya. And I think as Kenyans, we need to give this a try and see how it works in the expanded executive, and also do an analysis of what happens after election. And we compare with other elections, and we ask ourselves as Kenyans, do we have gains? If we have gains, we say yes. Let us do things differently, because we cannot have Kenyans dying every now and then. Anytime after election, people are afraid of going back to their farms. People are afraid of even meeting their neighbors. People are enemies. I mean, we are one Kenya. We are one nation. There is no room for us to become enemies. There is no room for us to hate each other. And I want to say that on the floor of this House, we must see how to deal with post-election violence. The elephant in the room, we are talking about very many things, but the elephant in the room is the leadership at the apex. We have to see how to deal with the leadership at the apex to ensure that it is representing the face of Kenya. Honorable Speaker, I want to say also, is my time up? Thank you. I want to say, Honorable Speaker, that when it comes to also clause 47, clause 47 seeks to amend Article 180 of the opposite gender rule. That is in election of county executives for the governor. If the governor is male, then the deputy is female, and vice versa. Now, this will be good because it is a good venture, because it is going to ensure that the 50-50 representation is not only in the Senate, but it is also in the county government. And this will also help the women come up and ensure that they're also getting mentorship from their governors, in a case where the governor is male. And in a case also where the governor is female, then the mentorship will also come up from the male counterparts. So I want to say, Honorable Speaker, that this Constitution is going to ensure that the inequality that is in Kenya comes to a stop. It is going to ensure that the discrimination and the marginalization that is in Kenya is going to stop. Because when persons with disabilities are given an opportunity in leadership and they're expanded, their voice will be stronger. And not only stronger, they're going to help others also rally behind them and ensure that they're supporting them. Honorable Speaker, I also want to talk about the fund that will go to the county. Honorable Speaker, 15% of the award fund that is going to the county will support in a big way, because it is going to ensure that the inequality in development that is in counties is also addressed. Honorable Speaker, even in wards, when you go to the counties, you'll find that there are some wards that are more developed than others. But even the 5% that will go to the wards will ensure that it is addressing the core issues we are talking about in Article 43 of the Constitution, issues of water, issues of schools, issues of infrastructure, and this will be a plus because families will gain. Honorable Speaker, we are mandated to represent the people of this country, and we can only represent them effectively when services reach wananchi. If services cannot reach wananchi, we are missing a point in this House, Honorable Speaker. But this bill seeks to ensure that 5% of the money goes to the counties. And it is very specific that this money is going to address the issues talked about in Article 43. Honorable Speaker, I also want to talk about the issue of equalization fund. I'm happy because the time has been increased. From 20 years, it goes to 30. Yes, I think that is also very good to ensure that we live in a nation that is equal. We live in a nation where everyone is enjoying the services of this country, the Honorable Speaker, so that no one is left behind. So, Honorable Speaker, with these very few points, I want to support the BBI bill, and I will not turn back. I will continue supporting because of these gains I've seen. Thank you, Honorable Speaker.
Thank you, Senator. Senator Olekina Ledama.
You allow me to talk. What is your problem? You allow me to talk. What is your problem? Time can start. Madam Speaker, I thank you. Allow me, for allowing me to say a few words in regards to this bill. To my dear colleagues and Kenyans, allow me today to disabuse you of the illusion that the BBI bill before Parliament is a perfect document arrived at in a flawless, perfect process that is supposed to solve all the problems that we have in this country. Madam Speaker, most of the things that I wanted to touch have been dealt with by my colleagues. So I'll try to demonstrate why I have serious reservation on the process and also particularly on this bill in very few words. I will focus my contribution today, Madam Speaker, in the following 5 areas. 1, the creation of the additional 70 constituencies. Number 2, the judiciary. Number 3, money to counties, and particularly focus on the issue of the Equalization Fund and the amendment of Article 203 and the introduction of Article 203N by this bill. And I will also focus on the role of Parliament in ensuring a fiduciary responsibility when it comes to the executive. Madam Speaker, without taking so much time, I will begin by focusing on one area, which I strongly believe that for the last decade, this country has made tremendous steps because of the judiciary. Madam Speaker, I've had a chance to look at the bill and also all the submissions. They're in 2 volumes. They're almost 2,000 pages by all distinguished people in this country, the Judiciary, the Law Society of Kenya, the IEBC, a prominent personality. And Madam Speaker, one of the things that really baffles me, which I want to focus on, is the proposed amendment to Article 168 of the Constitution. This essentially makes it difficult for any judge to be able to sit there and perform their duties when they know that they have security of tenure. Madam Speaker, the proposed removal of a judge simply because of a complaint is a very, very dangerous proposition. Madam Speaker, what the promoters of this bill are actually telling Kenyans is that so long as you have a case and you know that Judge X, Y, and Z are the ones who are going to sit to hear that matter, and you don't like them, you can sponsor individuals to file complaints, and the ombudsperson will suspend that judge simply because of a complaint. Madam Speaker, that is a very, very, very dangerous trend. We have survived in this country because of the judiciary. This House, the Senate, has been able to stamp its authority. Most of our bills, which were disregarded by the National Assembly, have now found life again because of the judiciary. So when you now create a very powerful ombudsman who has the powers to initiate disciplinary action because of a simple complaint by Kenyans, you know, you take away the presumption of innocence until proven guilty. Madam Speaker, that is a very dangerous precedent that we will be setting if we in this House clap and say the promoters of the BBI have given us a solution to our problems. Madam Speaker, I will get into the issue of the constitutionality of the entire process. I've had my colleagues, mostly the proponent of the BBI, alluding to the fact that this is a people-driven, you know, a people-driven constitutional amendment. And when I look at even the documentation and the BBI, it talks about the promoters of this initiative. We have referred to Article 257 of the Constitution. And some of my colleagues have alluded to the fact that this House can initiate changes. My view is that we cannot, because we are not the promoters of the bill. And I'll refer to Article 257 of the Constitution, Madam Speaker. Madam Speaker, Article 257(3) of the Constitution reads as follows. If a popular initiative in the form of a general suggestion, the promoters of the popular initiative shall formulate it into a bill. Madam Speaker, I would agree with my colleagues if this bill was originated in this House, because then the promoter of that bill would be a member of this Parliament, would be this Parliament. For now, Madam Speaker, and I know the same Article 257 talks about the fate. Whether we vote for this bill or not, the final say is bestowed by the people of Kenya. They are the ones who will decide the fate of this. So I want my people of Narok to know, and the people of Kenya to know that when I stand here and I raise my reservation in supporting this bill, is because I know it doesn't matter what my one vote will do. The ultimate decision, as per the law, falls under the people. And I think, Madam Speaker, if you read the report by the Joint Committee of the Senate and the National Assembly, they are alive to the fact. And in fact, when you read it, you will hear them dancing around and saying, well, this is unconstitutional, but there's really nothing you can do. There's really nothing we can do about it. And there are some other clauses where they come in and they say, this needs to be reviewed at an earlier date. Then what exactly are we doing? Madam Speaker, I've gone through the report, and I know the report is supposed to guide us or aid us in terms of our contribution to this bill, either in support or opposing the bill. When you read this bill, Madam Speaker, and you read the report by the Joint Committee of the Senate and the National Assembly, you will question whether this bill is the one which taxpayers' money was used to set up a steering committee to be able to draft that bill. Madam Speaker, I have come across 4 versions of the bill, not even 2, as I say. The first bill was the one which was launched at the Bomas of Kenya, October 21st, I think 2020. And when you look at that bill, when you go to Article 203 as an example, and you compare Article 203, the proposed amendment to Article 203, on the first bill is not the same as the proposed amendment in Article 203 on the second bill. Then it begs the question on the mandate of the so-called promoters of this bill. I have come across a Gazette notice that clearly stated that the mandate of that bill lapses June 30th, 2020. The second bill, Madam Speaker, which I've come across, is a bill dated the 25th of November, 2020. In this bill, there are two versions in regards to the second schedule. When you refer to the first bill of October 2020, the second schedule talks about the structure of the IEBC. But now, fast forward it to the second schedule in regards to the second bill which was published by the promoters, that is the one that is purported to be discussed in this House, that is two different versions, introduces a complete different thing which was never there in the first place. The issue of the creation of the additional 70 constituencies. Madam Speaker, I'm a firm believer that the framers of our Constitution as it stands were alive to the fact that it becomes very difficult for Parliament, or rather for anyone, to constitutionalize certain and protect certain constituencies and leave the rest. 290 constituencies, Madam Speaker, save from the few from Taita Taveta and Lamu because of population that have been protected by the Constitution. The rest can be changed at any given time. I live in Narok East, Madam Speaker, and if at any time the population reduces in Narok East, I might end up losing Narok East because Narok East is not protected. So, Madam Speaker, to attempt to say that you are now taking that power away from the IEBC and telling IEBC that as soon as this act has been assented to by the President, you have 6 months for you to be able to create these constituencies. You disregard what IEBC has told you, because if you read the report, Madam Speaker, IEBC has shared with you the practicality of setting up this 70 constituency, that it will not take less than a year. You forget that the same constitution states clearly that the referendum must be held a year into a general election. We are in May today. I want to see this magic that will come from somewhere, that we will propel IEBC with no budgets, corona period, for them to be able to go out there, albeit illegal, because these are not the views of Kenyans. It is the views of a few individuals. Madam Speaker, if you look at the letter which was signed by Chebukati, in that letter himself, in his communication, he indicates that the promoters of the bill are two individuals. One, who is a member of the National Assembly, Junaid Mohammed, and the second one is Dennis Wawero. These are facts on the committee report, the annexes which are there, that anyone in doubt can be able to go back and refer to. Madam Speaker, I am of the opinion that when you discriminate against 19 counties and you look at 29 counties, is it 29? You know, and say in these counties you can set up a constituency here and you name them, you're not only discriminating them, you're not only creating a disparity in this country, but you are also creating a problem that cannot be solved easily politically. Madam Speaker, I want to end that point by stating as follows. It is quite evident that the issues of constituencies, the issues of boundaries are very emotive. They are things that needs people to be consulted, convinced of the need to be able to set up, to alter boundaries, create new constituencies, new wards. And that is why the framers of our current constitution really took their time, because by the time we got the 2010 constitution, Madam Speaker, I dare say, the process that we took was a very painful process. Kenyans assembled at the Bomas of Kenya. They gave their views You know, even though that draft did not end up being the Constitution, but the final Constitution took into consideration what Kenyans all over had in mind. Madam Speaker, whoever the promoter of the bill is, because it is not Kenyans, it's either the Building Bridges Initiative or these two individuals who are noted here, ought to really think and ask a few questions. Are we amending the Constitution for short gains, or are we doing so for posterity? Madam Speaker, my third point comes into an issue that we fought so hard, which led to the arrest of our individuals, of our colleagues in this Senate, the issue of revenue. Madam Speaker, the promoters of this bill were defeated in this House, but they have found a way of introducing an amendment to Article 203. When we fought heavily against this issue of per capita, and I can see, how many more minutes do I have? 5 minutes, thank you. The issue of the per capita, they now find a way to reintroduce it by coming up with an amendment to Article 203, and they cap how much people can be able to get. Is this really realistic? And the argument they make there is that, oh no, we have the issue of the equalization fund. Madam Speaker, let me once again disabuse Kenyans of this illusion that this equalization fund actually helps. Currently, Madam Speaker, we have hospitals which were built, funded by that equalization fund. They are not in operation. The people who are supposed to have benefited never benefited. So when you tell us you're increasing the term, first of all, you show us the money. Tell us what happened to that money which was there that had been set up. Madam Speaker, you know, when we talk about the structure of governance, one thing that baffles me, and the question that comes to mind is this: does creating new levels of government, increasing the number of representation in this parliament, solve our problems? And the answer to that is no. Because when you look at it, the promoters of this bill, Madam Speaker, do not even want, they don't want workers to be represented in parliament. That is why they have sought to amend Article 97C and to do away with that provision of allowing workers to be represented here. I don't know what Sosion and Tom, who are representing workers in the National Assembly, would have to say about that, or even Atwoli, who on a daily basis talks about the rights of workers. He had a beautiful chance, and the Constitution of 2020 had given him that chance. Madam Speaker, the last thing which really questioned the motive of this bill is the issue of the role of Parliament once again, in terms of oversighting the executive. Now, there is an amendment, Madam Speaker, I think to Article 154, which really brings up the issue of removing the vetting of cabinet secretaries, the vetting of PSs. Madam Speaker, we're having a very difficult time right now oversighting these cabinet secretaries. Now, when you don't give Parliament that power to be able to vet them, are you not just going to be brewing a lot of impunity and corruption? What happens to the issue of integrity in this country, Madam Speaker? Madam Speaker, I want to end by saying the following things. I think I'm a firm believer that coming up with a proposal to amend the Constitution when you have not even implemented the first Constitution that we fought so hard for, you become an escapism, but not really a person who wants to be able to help this country. We need to think about the future generation in this country. You know, you can create so many goodies. You can actually say an MCA will be in the executive. So what have you done there, Madam Speaker? You have taken away that check and balance system in the devolved system of governance. Because an MCA who can become a CC will just team up with the governor, and when the MCAs now are either checking the governor, I mean, they'll just collude, and there's nothing you can do. So really, I would want us to be very critical, and I would want to be convinced that, first of all, interfering with the judiciary will help this country move forward. Second, interfering with the role of parliament will help this government go forward. And I'm not saying, Madam Speaker, that nothing is good in this bill. There are a lot of good things which can be amended based on amending the legislation. I want to end with the following words: that whether I vote for this bill or not, the law, the Constitution as it stands, gives the last word to Kenyans. I'm here to inform Kenyans as their representative. I'm here to point out areas which I think are wrong. 1 minute, yeah? And it's up to you. I thank you, Madam Speaker.
Thank you, Senator. Senator Mohammed Maalim.
Thank you very much, Madam Speaker, for giving me the chance to make my contribution to this amendment bill to the Constitution, the Amendment Bill 2020. Madam Speaker, in the memorandum of this bill, memorandum of objective of this bill, it is stated that the objective, the promoters of the bill state as follows: that the following issues are supposed to be addressed by this amendment. One is the need to resolve issues of divisive elections. B, promotion of gender equity in governance. C, strengthening of the structure of devolution and increased resource allocation to counties. D, the broadening of mechanisms for all people of Kenya to benefit from economic growth. E, harmonization of certain roles and functions of the bicameral parliament. F, fortification of national ethos by specifying the responsibilities of citizens. And G, the strengthening of accountability on public resources and the fight against corruption. Madam Speaker, it's important that as we look at this bill to see whether the objects and reasons for the bill as stipulated in the memorandum are fulfilled. Madam Speaker, we know since 2018, March 2018, when there was handshake between the President and the former Right Honorable Prime Minister, this country has been actually seized with the matter of BBI. In fact, the bill we have today, the Constitutional Amendment Bill 2020, has been referred to by Kenyans as the BBI bill. In fact, Kenyans are waiting for the BBI to be passed or be rejected. So what you have is actually the BBI report. The journey of BBI, as you remember, Madam Speaker, it started with the BBI's task force. The task force did bring a report to the nation. I think it was launched in Bomas 1, sometimes in 2019. Then there was a steering committee which was put in place for implementation. That steering committee did bring a report also to Bomas. We also what we had what we knew as the Boma 2. Then around that time, in fact, there were draft bills here and there. And between Bomas 2 and when the report was finally launched in KICC, I think there were drastic changes, and then we had this bill. Madam Speaker, why am I saying this? The question is, when you get views of Kenyans, it depends on what Kenyans have told the task force, what Kenyans have told the steering committee, and thereafter, where the promoters, who apparently became 2 members of parliament, 1 member of parliament and a former member of parliament, who submitted the document to IEBC, whether the ideas that were collected and how were they collected properly. Madam Speaker, having said that, we in this parliament You know, Parliament under Article 94 of the Constitution, if I may read, 94, the role of Parliament, the legislative authority of the Republic is derived from the people, at the national, the people, and at the national level is vested and exercised by Parliament. 4, Parliament shall protect this Constitution and promote the democratic governance of the Republic. Madam Speaker, this Constitution, which was enacted in 2010, was a result of a lot of discussions for many years. In fact, we are now having a bill to amend the Constitution. And the framework of the Constitution 2010 and Article 257, apparently when you have, you know, public initiative, you cannot amend. But one wonders, if you are amending a Constitution, why can't you amend the proposed amendments? You know, we are amending the Constitution, and we are told you cannot amend the amendment, the proposed amendment. So there's a fallacy here, Madam Speaker. Madam Speaker, I would like to congratulate the committee, Joint Committee of Parliament, of Senate and National Assembly, for a job well done. I think in the difficult circumstances that they were put in, because the bill, the way it was drafted, had a lot of, you know, confused articles, with a lot of problems. And in fact, this bill, you remember, you know, in Kenyan psych, and a lot of people have been talking about it. A lot of people have been owning the bill without even knowing what is there. And in fact, we have been told one time, you either take it or leave it. That's a bitter pill to swallow. It's very unfortunate. This is the Constitution of Kenya. A Constitution of Kenya which must be protected and safeguarded by all Kenyans, and more so by people in the executive and also Parliament, who are representatives of the people. Madam Speaker, the committee did a good job because they've actually sieved properly this bill and have come up with the issues that are proper and which are improper. These are unconstitutional, not unconstitutional. Then I'm surprised, you know, if you have, you know, recommendations from the committee that this is unconstitutional, then how do you proceed again to say we are going to amend the Constitution? Madam Speaker, we are at some crossroads. Madam Speaker, the committee has done a good job. I think they have really highlighted all the issues. But again, as we are told, our hands are tied. We are told that the parliament role is ceremonial. Again, the argument is not, we are not ceremonial. We pass to the people. We cannot, you know, passing something which you know is bad to the people and accepting them to just do it. I think we are just resigning ourselves to something which is unnecessary. Madam Speaker, where we are today, we are having this bill before Parliament. Parliament has either to reject or pass. No, but I think our people outside there, the Wananchi must listen properly so that, you know, I hope by the time this bill goes to the public will be properly educated. There'll be proper civic education that we don't allow our people to pass unconstitutional, you know, amendments so that, you know, it is something which is going to work for Kenyans in posterity. Madam Speaker, the bill in various articles addresses, you know, amendments. I would like to look at a few because a few of them, Parliament, the bill proposes to increase representation constituencies by 70 constituencies. Fair enough, you can increase the constituencies, but it is not proper then under Article 89 of the Constitution for you to go ahead and again to allocate those constituencies to counties. That role is for IBCs. Unless the whole of Article 89 is amended, we remove the whole of it and come with a new thing so that, you know, we can now allocate the constituencies to counties. I think it's not proper. I say this even with the knowledge that my own county, Mandera, is getting a constituency. I'm happy for that we got one. But I think the process in which it was done is wrong. Because, you know, the idea of allocating the constituencies is actually that delimitation and demarcation is the IEBC's role. It is not right to do something unconstitutional. So I think the committee has recommended and say that, you know, this is unconstitutional. How do you deal with this? Now, because for selfish reason, because the Kenyans are very selfish, I will support maybe, I have at least one. 70 has been distributed. Mandela has one. Tick, I can say that. But I think the process, it must be said, is wrong. Madam Speaker, if we look at the issue of resources allocation, Article 203 of the Constitution has an elaborate way, elaborate criteria set out clearly what criteria must be used to allocate resources between counties and also among counties and also between national government and county governments. Madam Speaker, this constitution amendment, this bill introduces 3 other criteria. The first one talks about to avoid corruption. I don't know how you can, in allocation, you talk about corruption. I think it is superfluous. But the worst one is that when you bring in the issue of per capita. Under Article 217 of the Constitution, this Senate, of course, Parliament originated by Senate, is supposed to come with a criteria for allocating money between counties, among counties. And a few months ago, we know what we went through here. Then you develop a criteria, you have a formula, then you say this is the base for allocation. Then it's like you're doing an exam, you say, okay, criteria. You remember CRA came with a lot of parameters. We look at the parameters, then you score. Every county score, you get it. Then you come back and say, no, you negate it and make sure that you cap it at this level because some counties are not supposed to get money. Madam Speaker, this particular provision in 203 is illegal. It's illegal because it is actually profiling and targeting people. It's actually discriminating against people. It's discrimination. The Constitution of Kenya does not allow discrimination. In the last debate we had here, you will all remember what we went through. Now, we came out of that victoriously because we did agree with the executive to how to overcome that. Now, somebody will say, no, it's not enough, come and cap it. To make the matter worse, they have not realized that what they are doing actually is not even practical. You cannot, if you say now the allocation to the highest per capita county should not be more than 3 times, then if you do that, what do you do then with the balance of the money? You cannot take out some counties and divide the money among a few counties. You cannot do that. So I think it's not even practical. But more than that, I think it's totally illegal. But I'm surprised with also the recommendation of the committee because the committee says legislature and the executive must come with some way out. I don't think they'll come with some way out. How will they come out? Because the Constitution has been amended. The matter has been put in the Constitution. So I think for that purpose, I think this matter is totally wrong and it's totally unacceptable. Madam Speaker, if you look at the amendment that's proposed again, the judiciary, in this country, we had a history of where, one time Parliament was under the executive, the judiciary was under the executive. Then we had, the whole thing liberalized, and we have the Constitution of 2010. Judiciary is independent, Parliament is independent. Now we want to claw that back and bring amendments to the Constitution so that, JSC, first of all, you make JSC be able to discipline judges, sack them, what do you call it, suspend them. These are all legal. I think what we have in the Constitution today are important, are right, but the amendments are actually not proper. The police, the National Police Service, we reform the police, and I think amendments are being proposed in the Constitution again to claw back what was done so that, you give a lot of power to the IG. I think we should be content with having an independent police force so that the commission can be able to do its job properly. Madam Speaker, article, the amendment, we have the amendment, proposed amendment where you talk about shared prosperity in terms of economic development, all these things. Agreed, Madam Speaker. I think every day in this country, what we are seeing is actually negating that particular proposal because, Kenyans as a country, we want us to be having equal opportunity. People, there's equity in the country so that, people of this country are considered properly. If you look at the appointments today, if you look at how things are done today, if you look at how development is done today, all these things are not equitable. Madam Speaker, I think you should not just be paying lip service to the Constitution, but mean what we say and actually do what was supposed to be done. Madam Speaker, the I have said about the amendment to the Constitution in terms of the 70 constituencies, those the way they are allocated. I think even in population quota, even the IBC can do it. IBC could be the right person to do. But, Speaker, the structure of the executive has been changed. They are proposing the Prime Minister, Deputy Prime Ministers. But the surprising thing is that, vetting of cabinet secretaries and executives have been removed. I don't know the reason. I think it's not proper. It's not proper. Initially, one would have thought that, if you make, the executive join the parliament, so that, ministers are from on the parliament and some from outside, then you can have the vetting role to the Senate. That's not been done. Not been done. Now, Senate cannot even summon ministers, I think, the way it is. Permanent secretaries. All these are actually not going to be vetted. So I think this is also a clawback. We have gone a bit backward instead of going forward. Whereas maybe the idea of having cabinet ministers in parliament makes some sense, but the issue of vetting and responsibility and the matter of separation of powers has not been properly addressed. So I think Senate should have been made the one to vet cabinet secretaries and principal secretaries. Madam Speaker, proposal is being made, or an amendment is made to strengthen the Senate, Article 96, but it's not enough. I think Article 96 should have explicitly said that the Senate is the upper house. Senate, vets the cabinet secretaries. Senate vets it must be been properly done. But it has gone short and just say, we are going to have access to overseeing own resources. I mean, that's a very small thing. Own resource money is very little. So I think the role of this House has actually been relegated to a very low level. This House has actually been really, the promoters have been, whoever it is, I think the promoters are now very many, have been very unfair to the Senate. So I think what this matter will now leave the Senate, the Parliament, it will go to the public, the Wananchi, those are our people. But I think ultimately the Constitution that we are going to have an amendment, because this amendment, amendment is supposed to be a small change to something normally. But this is a radical change. This is a radical change, frankly. I mean, it is like rewriting the Constitution. So we hope all the best for this country. Selfishly, I will say, because Kenya is selfish, I'm happy with the one constituency I got in Mandera. Yeah, I got one. But my neighbors didn't get Wajir, Garissa didn't get, other people, Habaswein didn't get Wajir, South, Marsabit. Oh, this is wrong. You see? But I think, you added 70. Why 70? Why number 70 first? Why not 60? The other one is that, Parliament. The women, the National Assembly, 47 county assembly women have been, 47 women rep have been removed. Now you make this House 94. What's the logic? What's the logic? Make it 94 here, put the women there, leave them there also. Then you limit the number of people who are going to nominate them. The women of Kenya must not be left to the tokenism of nomination. They must be allowed to contest seats and win. If they are given the 47 seats in the assembly, 47 plus 47, 94. In fact, the number already, then the number going to be nominated will be fewer. A few of them will get elected in the constituencies. So I think whoever the promoters were, they have not done justice. But because BBI has been, the rallying call in this country, and that anybody who opposes BBI as anti-government, anybody who's opposed, I don't understand this side, frankly. The side in Kenya. We must change the way we do things in our country. So the bill is now before us, because whether we vote yes or no, it will still go to the people. But our people must be properly educated. There must be proper civic education so that people will vote for this. But I think there is no miracle also this is going to solve. The bill is not a miraculous solution to Kenya's problems. It's not a panacea to Kenya's problems. Kenya will not be a first world by having this bill passed, because elsewhere we say that Kenya will go to first world by doing this. Our problem will still be there unless we change the way we do things. Unless we change the way we govern ourselves, whether we have this bill passed, whether it's in the form the promoters want, I think we'll be there. With those many remarks, Madam Speaker, I wish to contribute my contribution. I thank you.
Thank you, Senator. Senator Pareno, Judith Ramaita.
This one is okay. Thank you, Madam Speaker. I rise to support the bill and support as well the committee's work. I thank the committee for a job well done, very good analysis. And of course, the chair was here taking us through the deliberations of the committee and what they felt needed to be done. Madam Speaker, we definitely know where we have come from and how we arrived at this particular moment of constitutional amendments. And definitely would want to go back where we were in 2007 or even 2017, where at some point we felt, some of us were actually convinced that we needed to divide this country into two so that those of us who are oppressed can go their way, and those that were feeling comfortable in the system could also go their way. But of course, we know that the handshake came in to save this country. And we also know that the handshake led to BBI, which speaks for itself, building bridges for this country. And thereafter, this has been reduced into this draft bill that we are debating today in this parliament. Madam Speaker, I have had time, of course, to read the BBI report initially. I have had time to read and to appreciate the bill as drafted, and also to appreciate the concerns that have been raised by the committee as they were considering, the joint committees, as they were considering the BBI, the Constitutional Amendment Bill. And Madam Speaker, I've taken time to direct my mind into certain sections of what has been provided for in this bill. So I will look at I'll be talking about clause 9, which talks 9 up to 13, talks about the 2/3 gender rule and inclusivity. Then clause 50 on equitable share of revenue, and 51 as well on equalization fund. Then clause 50 again on increase on revenue to the counties to 35%, and the ward fund as well as the assembly fund. Then finally, I'll be talking about the implications as analyzed by implications of these amendments as analyzed by the joint committee. So, Madam Speaker, I proceed to discuss or make my comments on clause 7 of the bill, which proposes to amend Article 82 of the Constitution on legislation on elections in order to mandate Parliament to enact legislation imposing sanctions on a political party that fails to ensure that no more than 2/3 of the party's candidates are of the same gender. Madam Speaker, we have had a problem with the 2/3 gender rule that is provided for in the Constitution of Kenya. This has come in handy. It's a plus that in this clause, we are amending the articles of the Constitution to ensure that political parties actually submit a list of candidates that complies with the 2/3 gender rule. But, Madam Speaker, I feel that we should have been more bold about this. This provision is like giving in this hand and taking away from the other hand. And why do I say that? Madam Speaker, political parties will submit, I know, like the political party where I have been all my life, in my political life, ODM, will definitely comply to submit the names of candidates that will comply with the two-third gender rule, like it has done in a lot of other structures of the party. And like we have done when we do grassroots elections, we actually submit to IBC. Every time we do grassroots elections, we always take care of the two-third gender rule. But I want to say that this does not expressly mean that we will achieve the balance at the end of the day, at the day of election. Because we will submit yes, IBC will compel the parties yes to submit those, the list that has, that complies with the two-third gender rule. But how will we force the electorates to comply at the time of the ballot? So it simply means that this provision has given us on this hand, but has taken away from the other hand. Because at the end of the day, you might still, at the end of the day, find that the electorate will not have elected the candidates that you have submitted, and the result of the election will be that you don't have the balance anyway. So I feel like it was short of just doing the right thing. I feel like this provision has not been bold enough to ensure that there is gender parity and there is the respect for what the Constitution has provided for, in as far as bringing in even women to leadership. We should have been more bold and just simply state that at the end of the election, we should have had parties promoting and ensuring that the candidates that they submit will actually come successful after the ballot. Madam Speaker, Clause 8 of the bill proposes to amend Article 87 of the Constitution, which also now brings in the electoral disputes to be handled by another mechanism other than the mechanism that had been provided for. I am happy that I'm one of those that suffered so much because of lack of provision in terms of, or let me say my party suffered so much because of lack of proper provisions as to how to handle disputes. In fact, Madam Speaker, I was in and out of court for the entire period of nominations of ODM for 2017 until the one day before the general election. I was still in courts, being sued left, right, and center. The party being sued left, right, and center. People pretending that they are even serving orders when they were not serving me, they were not serving the party. In fact, Madam Speaker, there's a day I woke up and saw in the news that Senator, by that time I was not Senator, Honorable Judy Pareno be arrested and be brought before a court of law within 24 hours. And I just saw it in the news. Only for me to inquire, and I'm told that a purported court order had been served somewhere and it was not served on me, and the court felt that I was in contempt. So a procedure that will help the political parties handle these disputes is good to be enshrined in this amendment. And definitely, this amendment has also, we have another amendment where the IBC is no longer going to handle disputes that arise from nominations of political parties. I always felt it was a conflict of interest, and it is good that IBC be given to concentrate on their mandate, while another mechanism is brought on board for political parties to handle disputes that arise out of their nominations, while IBC can handle the disputes that arise out of their own election. So this is a plus, Madam Speaker. And the reasons why we are highlighting that which we support in these amendments. Madam Speaker, Clause 9 is still the same. I have talked about that conflict of interest for IBC to be handling disputes arising out of nominations, and it is good that we move away that which was not really a mandate, because I don't think that was their mandate, but they had to step in because there was no provision at all. Madam Speaker, Clause 13 of the bill proposes to amend Article 97 of the Constitution on the membership of National Assembly to increase the membership because of the additional constituencies, and also to increase, to amend, to create special top-up seats. And this is another plus to try and handle the issue of the two-third gender rule. Because if we don't achieve, like I have said, you might even submit the list of candidates and the electorate do not choose, so you end up not achieving, then there'll be a provision for top-up. And at the end of the day, we will achieve in the National Assembly, because at the Senate, Madam Speaker, I am one of those who is happy that now there shall be, after we pass this bill, and after the referendum, is because I'm really hopeful that the Kenyans will pass this, because this arose out of their own submissions, that we shall have 2 senators, 1 woman and 1 man, and specifically this provision will actually also address the issue of us looking like just, I don't know which term to use, but normally when I speak in this assembly, in this Senate, and what you speak about, you are not even able to vote for, it's another person to vote for you, it has always felt bad. And I think this is the time that at least as nominated, there'll not be nominated senators, but there'll be equal senators, men and women, who can vote for whatever that will be on the floor of the House. And I'm happy that this bill proposes to bring in that amendment of having 1 woman senator and 1 man senator with equal rights in this House. And of course also the top-up issue with the National Assembly, so that then as we get the 50-50 membership in the Senate, then we also have at least not more than two-thirds of the agenda in the National Assembly. So this is notice to the women out there, because there is a provision that you can, in this BBI, there is a provision that you get priority to be nominated in that top-up list only if you have attempted to run, and they will look at the votes that you garnered while you are running for the constituency seats. So this will encourage a lot of women to come out, because if you don't run, then you don't have that priority. Although we have an issue there, because suppose people don't run in a particular constituency and women do not come out and run, where will you take those slots that they are supposed to be allocated to particular, for that top-up? Suppose they don't come out. Do we say that there is a constitutional crisis, or do we have another option or another criteria to use to pick women in that top-up list? So, Madam Speaker, I support that provision to increase women by top-up and by making the women senators equal to their peers in the Senate. Madam Speaker, then there is very important provision, Clause 50, amending, that proposes to amend Article 203. And this is so sensitive, Madam Speaker. Madam Speaker, new parameters have been introduced on how we will share revenue. But I must say that as a pastoralist, and as a person coming from those that have been marginalized for a long time, I am not happy with this provision and the way it has been brought in, or the way it has been crafted. In fact, I was asking myself why they crafted it in the way that it has been crafted. And it would have been so easy for us, as we say that we are passing this bill, for us to be so happy that those that did the drafting did their work well. But on this one, I must say that it was not properly done. Why do I say this? Madam Speaker, Clause 50 of the Constitution of Kenya, Clause 50 of this amendment to the bill, Clause 50 of the bill, the proposed bill, that seeks to amend Article 203 on equitable share of revenue, is seeking to expand the criteria for determining the equitable share of national revenue to be allocated to each of the counties. And remember, the original provision of the Constitution of 2010 indicates that the criteria in 203, the following criteria shall be taken into account in determining the equitable share provided for under Article 202 and in all national legislation concerning county government enacted in terms of this chapter. And it says the criteria to be used is, first, the national interest, any provision that must be in respect of the public debt and the national obligation, the needs for the national government determined by objective criteria, the need to ensure that county governments are able to perform the functions allocated to them, the fiscal capacity and efficiency of county governments, development and other needs of counties, economic disparities within and among counties, and the need to remedy them. I emphasize on that one because this is where some of us lie, that there are economic disparities within and among counties and the need to remedy them. The need for affirmative action in respect of disadvantaged areas and groups. The need for, that is also touches on some of us. The need for economic optimization of each county and provide the activities, incentives of each county to optimize in the capacity to raise revenue and the desirability to stable and predictable allocation of revenue. Then now this bill seeks to just water down these provisions that Kenyans had done in 2010 as to why we should be, we should take into account all these parameters. So I am particularly not happy with this kind of crafting. Because if you look at the provision on issues of equitable, on issues of equalization fund, why did we bring an equalization fund in our 2010 constitution? Because some of us were left behind while the rest of Kenya was developing. Because we came to realize that we are one country, one people, one destiny, and we should equally share these resources. Because we should bring the rest that had been left behind to the same level of those that have developed. That is why the equalization fund was brought in. What happened to the equalization fund that affect the ones that have been marginalized? It has never been implemented to date. If anything, I am happy a little that this bill seeks to extend the time frame for which the equalization fund is going to operate. It has extended to be 30 years instead of the 20 years. But what has happened with the last few years since the 2010 constitution? Nothing. The equalization fund has not brought us equal to the rest of the communities that are ahead of us because they had advantage, because they had the president then. The Maasais might never, or let me say, the Maasais might take so long to ever realize to have a president or even a deputy. So are we going to wait forever for us to be brought equal to the rest of the communities? So why did we water down this particular provision by bringing in new provisions to enlarge the criteria, but removing the very core provisions that we still feel that should be there? So, Madam Speaker, on that one, I am happy that the committee has observed that provision has removed the very basics, and we need to relook at what we need to do to be able to make sure that no county is going to lose by virtue of these provisions having been removed. So I'm happy that the committee has advised, in as much as people would want to say that we are just a conveyor belt, we are not. We will state what it is that needs to be done, and we'll be watching to see that what needs to be done is going to be done, because that is our job as legislators. So, Madam Speaker, I am happy that the revenue allocation to counties is going to improve. That we are going to have, instead of 15%, by passing this bill, we are going to have 35%, which translates to almost 2 times or 3 times the current amounts that we are getting as counties. This is a plus. But we should not erode it in such a way that by the end of the day, that 35% will be equal to nothing by not making the necessary provisions for us to be able to realize this. I'm also happy, Madam Speaker, that in this bill, the county assemblies shall have autonomy. They will have their own fund. You can imagine a county assembly members having to kneel before their governors for them to be able to run an assembly. So this is a very good provision. The 5% increase, the 5% allocation fund to the Ward Development Fund is also another plus to our counties. because each county then will have its own share, irrespective of who you voted or irrespective of those parameters that are used in the counties to be able to allocate money. But, Madam Speaker, just to touch on an issue on the EAC, now that this bill also talks about EAC, and having been a member of the East Africa Legislative Assembly, we were there last week to inaugurate or to celebrate the appointment of our own Honorable Mathuki as SG. And what I was told by the members there, who are my former colleagues, is that for the last 6 months, they have not been paid any salaries. Members of Parliament have not been paid for the last 6 months in the EAC. Madam Speaker, if you could just give me 2 minutes, I'll wind up.
1 minute.
Yes. And why? Because the Secretary General then had refused to sign in any money. So it is important for us to think about how the assemblies all over, both the county assemblies and even the EAC assembly, to be economically empowered, and they should have their own autonomy when it comes to their budgets. So, Madam Speaker, finally on the judiciary, I feel like that provision of the Ombudsman is going to infringe on the rights of those judges. You cannot be sitting there to wait for a judicial service commissioner to be the one to recommend to remove you. The tenure of the judges should be protected. And to me, I think even as we pass this bill as it is, we should look into the independence of the judiciary just as much as we have the independence of the legislature, and the executive can do their bit, and they let us do our bit. I thank you, Madam Speaker.
Thank you, Senator. Senator Hargura Kodana.
Thank you, Madam Speaker, for giving me this opportunity to contribute to this very important bill. Madam Speaker, what we are dealing with is the first amendment to the Constitution of Kenya 2010, and the main gain or the cornerstone of the Constitution of Kenya 2010 is devolution, where parts of this country which have been left behind at least felt that now they can address their issues, because the main issue is resource allocation, representation, and even self-governance at the county level. Madam Speaker, when we are to amend this constitution, whether by popular initiative or parliamentary, my understanding is that we are improving. And I'd like to look at, based on that aspect of devolution, what we have done in this, or what the proponents of these amendments by popular initiative have brought in, which will enhance that. First, I'd like to look at clause 49, which amends Article 202. And in that one, you'll see that when we were sharing resources, there was that aspect that we look at the recent audited accounts, approved audited accounts by the National Assembly. And they have already been very much behind. Like this year, in the Division of Revenue, we used 2016, 2017. And that is why, when you look at the Division of Revenue bill, it was talking of, it was giving 27% of the resources to the counties, because it was based on an old financial year. So what this one does, this amendment is timely, because it says that it looks at the latest audited accounts by the Auditor General. Like right now, had we had it closed in the Constitution when we are doing this year's Division of Revenue, we would have used 2018-19, which would have shown that actually the 370 would have been even less than 20%. Now, these amendments will enhance the second amendment. So this is a very good amendment, and this way then will be making progress in terms of enhancing the allocation of resources, in terms of financial resources to the counties. That is clause 50. Then that's clause 49, which was amending Article 202. Then clause 50, The second part, which amends, Article 203, Clause 2, increases the shareable percentage to the counties from 15 to 35. With now the Clause 49, then 15 to 35 now will be meaningful, because if Clause 49, Article 102 was not amended, then we'll not be having any much gain from 15 to 35, because we're still using an old account. Now, Madam Speaker, the one which I have issues with, and which has been raised by many of the senators who contributed, is Clause 50A, which amends Article 203, Clause 1, which introduces the issue of capping. Madam Speaker, we already, when we were discussing, first of all, in the issue of coming up with how the fund is shared, the Constitution already has given very clear guidelines that every 5-year Senate is supposed to come with the basis of the shareable revenue. And that's what we have done. Like in the last year, for 10 weeks, Senate has been on that, coming up with that shareable formula. And in that formula already, if we can remember what we went through, already population has been given prominence. Up to 70% or so of that money is based on population issues. And for the marginalized areas, the arid and semi-arid areas, which are sparsely populated and have bigger landmass, and we know when you talk of a country, we talk of the territory and the people. I don't know why when we talk of resources, we want to talk only about people, and we know that these resources are shared, services delivered based on the way the people are settled. In a sparsely populated area like my county, there's a lot of, the cost of delivery of service is much more than in a densely populated county like Nairobi. So already Article 217 gives us how that formula is generated. And in that formula already, the marginalized areas, the sparsely populated areas already have been jeopardized, because we know very well the land area has been capped when we did the formula. Now, after having that formula, after what this amendment is saying is actually, yes, you have the formula, put in the variables. If you have, for example, 370, once you have calculated and you have generated for each county, then go back again and look at what the per capita for maybe the most densely populated county like Nairobi is, and then no county gets more than 3 times that per person. You are already introducing another formula on top of that formula, which some of us feel already we have been jeopardized by capping population. Now, this is a case of what we will call double jeopardy for the sparsely populated areas, because you are introducing that capping again. So that is why actually the committee in their report found an issue with this. And this is an area which needs to be looked at, and these which disadvantages already disadvantaged areas. Maybe if I tie in with the equalization fund on this one, because the argument has been the marginalized areas will benefit from equalization. Equalization fund, which is 0.5% of the revenue, has not been utilized for the last 10 years. Since the promulgation of the Constitution, it has not been utilized. And the sunset clause is that it runs for 20 years. Already 10 is gone and nothing has been done. We know there is an issue where in 2016, I think there was a court case ruling which suspended the use of the mode of implementation. But I'm wondering, because the Constitution is very clear, the national government can use it directly, or it can give it as conditional funds to the counties. It's very clear. Why we are running about that is an issue of lack of goodwill of implementation. There's nothing else. So equalization fund, saying that it will run for, okay, the clause 51 amends Article 21 saying that we extend the period from 20 to 30, we are just still saying we are going to use it only for 20 years. But the problem is, for the last 10 years, the executive did not find any goodwill to come up with the necessary enabling regulations or legislations to implement this. What assurance do we have that anything will happen in the next 20 years? Because that is what is left. So nobody should look at equalization and say we are capping on this end because you are benefiting on the other end, because that benefit is not there. Madam Speaker, the other issue is Clause 13, which amends Article 97, introducing, changing the number of constituencies from 290 to 360, the 70 new constituencies. Yeah, it could be 100, it could be 70. Yes, the proposers of the bill can come up with any number. Parliament itself can also change that clause. But once that need has been felt, that there is more representation required, then the technical aspect of determining where will these extra constituencies go should have been left to the technical commission, which has been created by this constitution. That is why the committee, I think, went ahead and said this is an unconstitutional constitutional amendment, because it's conflicting already existing provisions in the Constitution. And when these extra seats are created, as somebody representing Marsabit County, which is the largest county in this country, and we have one of the largest, actually the largest constituency in Marsabit, in Kenya, which is Northor. I mean, when you only consider population, and you have one constituency covering 40,000 square kilometers, several counties in this country put together, then that constituency, I'm sure the residents are suffering because they cannot get service, because 40,000 square kilometers, you're giving the same amount of CDF as you're giving a small constituency in Nairobi, and the cost of service delivery is very different. So I think that's why we are saying, yes, come up with any number you want, but leave it to IEBC to look at all that, collect views, so that even at the end of the day, if there's anybody who feels left out, then the IEBC outcome can be challenged in court, unlike this process. So that 70 constituencies and the way it has been, basically the schedule should not have been in that bill, because the schedule is selfish in the sense that people come up with numbers and distribute among themselves and put it in the Constitution and expect Kenyans to pass for them. That is being selfish, and that schedule should not have been there. Madam Speaker, the two-third gender rule, or let me go to Clause 12, which talks of the Senate oversight. It enhances our role, yes, because initially, Article 96(3) talks of Senate oversighting only the funds allocated to the counties from the national resources. While we know counties generate their own, they receive also funds from other sources. But this one now talks of now amending that and saying that all funds received by the counties, whether there is their own source revenue, whether they receive from other quarters, whether they receive from national government, is all now under the oversight of Senate, and that way we'll avoid the case like the one which has been cited today in the morning, where the governors had to go to court at the beginning of this devolution to stop Senate from oversighting their own source revenue funds or funds they get from other sources, because the Constitution says we only oversight funds from the national government. That is good, because it makes it clear that the governors have to be oversighted for everything, because the auditor's report does not discriminate with the source of funds. They audit all the funds which the county received and expended in that financial year. So when it comes here, then there is no way Senate can be told you cannot oversight its own source, you only oversight national. Lastly, on the issue of the two-third gender rule, Madam Speaker, yes, we are alive to the fact that last year, under Article 261(7), the then Chief Justice gave an advisory to the president to dissolve parliament because we couldn't meet that, or we couldn't come up with the legislation to operationalize that aspect of the Constitution. And now maybe this amendment to the Constitution is a way of coming up with that, a solution to that. But Madam Speaker, the issues which I find difficult here is we are creating more constituencies, yes, and the National Assembly, where actually the main oversight is, because that is where the national government is oversighted from, and that is why where even now the national government is going to be represented. That is where I felt that the women need to be empowered to the extent that they can be part of the government process, because that's where the decisions are made, and those decisions affect women also. And having been in Parliament now the second term, being elected and being nominated are two different things. Because when you are elected, you have been elected by members of the public, you owe your responsibility to them, you will be working for them. But when you are nominated, then that value addition to the electorate will not be there, because you are just nominated by a party, and at most what you'll do is to be loyal to that party. So the larger women folk of this country will not feel any service from you, because you will not be answerable to them, you will be answerable to your party. Achieving two-third gender rule, two-third numbers in the House is not enough. Let that two-third be by people who actually have that mandate, who will be improving the welfare of the gender they are representing. And I thought the issue of women reps in county assembly was a better way to go. Yes, if the issue was women competing with men because of the political environment has always been seen to be a problem, then creating seats like the women rep seats will have them have a competition among themselves, but once they're in parliament, they are representing the electorates who elected them, so that we minimize and move out of this issue of nomination. In any case, the Constitution still puts a sunset clause on that. So what happens after that? Have you prepared that affected gender to be able to participate in elections or in competitive election after the 20 years? We must have a way of engaging. It's better if it was actually the women rep type, then that way we can improve. Even if the numbers were increased, then it would have been better. As for having in Senate equal numbers, I have no issues with that, because like even the American Senate, I think each state is represented by 2 senators. So how they relate is how we should be relating, because sometimes you may have 2 senators from one county, but on the opposite sides of the House. So how will we be coordinating and representing the county when we are on opposite sides of the House? Those are some challenges we'll grow with as we progress, and I think that will make sure that we improve the representation, and we also improve the gender equity. And Madam Speaker, with that, I say that there is always room for improvement. In this bill, there are areas, like I concentrated on areas which I think enhance devolution, especially on that aspect of resources. If we are going to attain that, then I'm sure counties will develop, we'll get more resources. But the Article 203 clause on capping has effect. Just to say, in case of my county, Marsabit, yes, we may not get less than what we are getting, because already the shareable revenue has been increased by using the current revenue, audited revenue. But if that capping was not there, then we'll get 4 times per capita of Nairobi. But now you have a 3-time maximum has been introduced arbitrarily without any scientific backing, and automatically Marsabit will lose a quarter of whatever it was supposed to have gotten. It may be more than what we are getting now, yes, but we are still losing a quarter because of this kind of arbitrary insertion of these clause, and I hope, as we have been told, the only way out is to wait for it to go through and go to seek constitutional interpretation. Maybe that is an area people from the affected counties have to look at and see how we can remove that clawback in revenue which has been introduced, which basically to me it looks like a backdoor introduction of one shilling, which we defeated during the revenue formula debate. Thank you, Madam Speaker.
I see Senator Cherargei is not there. Mary Senator is not there. Senator Mudama, Agnes Kavindu.
Madam Speaker, thank you for this opportunity to support this bill. To me, this is a very important document because I am a mother. And Madam Speaker, I wanted to go on record that somebody, a senator in this House, said that the committee went round the 47 counties just collecting signatures, and I want to say and make it very clear that we went around the 47 counties. The committee went around the 47 counties taking or collecting views of the citizens, and even took views of stakeholders in Nairobi and almost everywhere. They worked with the citizens. And I want to say this is a very important bill, and if it is passed, Kenyans will benefit with many things. Because when you go to devolution, they recommended that counties get 35% of revenue instead of the 15%. And even the ward fund, development fund, 5% to the wards. There are benefits of women, and even they've suggested of ways of how to have enough women in Parliament and even in the Senate. Madam Speaker, they've also suggested about the Youth Commission, which will have youth, including PWDs, and they'll have a voice in this nation, which our youth has really been crying for many, many years. And given that this bill will pass and will go to the referendum, and those clauses will be changed, women, youth, and even PWDs will benefit a lot. With the microfinance also, SMEs, they will also benefit a lot. And Madam Speaker, I want to speak about the official opposition leader in this country. We really need an official opposition leader in Parliament to have checks and balances to see what the government of the day will be doing. And this will bring down corruption in this country. They've also suggested of ways of how the cases of corruption should be done for not long, but for a few months, and then they are done with. Madam Speaker, it is important for inclusivity for us to have the Prime Minister and the deputies and the official opposition leader, so that most of the areas will have representation in Parliament. And I believe, even because those seats are not enough for the representations, the other appointments will cover and people will feel that they are included in the government of the day. Madam Speaker, still talking on that, we've always had fights after election, after every 5 years, and this country goes into war, and we waste like 2 good years of fighting, taking one another to court and all this and all this. And I believe, Madam Speaker, if this bill will pass, this will be a thing of the past for our country. When you go to 115 of this bill, clause 51, they've also proposed that Article 204 be changed for equalization funds for the marginalized counties, which is to bring them to par with the counties that are ahead of them. And they've also suggested, because for 10 years it has not been used, so they suggested it is moved to 30 years instead of 20 years, so that they can recover the years that has been wasted. And I believe that will bring them to par with the other counties. Madam Speaker, there are a lot of benefits in this, because the SMSs are supposed also to get the 7 years holiday without paying tax after they start their new businesses. And that will enable them will enable their businesses to stabilize and be able to move on. Even our university students, the loans that they are given, the report or the bill also suggests that they are given like 4 years after university so that they can find jobs, work, and then start paying for that. And there are a lot more benefits in this document if you go through it nicely. And I stand to support this bill. Thank you.
Senator Milgo Alice Chupkoril.
Thank you, Madam Speaker, for this chance to also weigh in on this bill. I wish to say I support this bill, more specifically coming at the backdrop of challenges that have been facing our country for many years. Madam Speaker, His Excellency, the President of this country, together with the Right Honorable Prime Minister, came together in 2018, and in their communique, they came up with about that is 9-point issue. Notable among them was the ethnic antagonism plus competition. There was issues surrounding inclusivity, divisive elections, lack of equity in resource allocation, as well as gender, among others. Madam Speaker, out of this, of course, there was a task force that went on to collect suggestions and opinions from people, and as stipulated in the Constitution, this culminated in the popular initiative bill that is before this House today. I want to thank the chain committees for burning their midnight oil to come up with such a very refined bill from such a huge document at a very short time. Madam Speaker, while there are very many contentious issues in this particular bill, there are very many good clauses in this. And just like the Constitution 2010, there are very many other contentious issues that were supposed to be amended even before passing. And I'm sure amendment is open very many times to a Constitution. I remember the American Constitution has been amended over 57 times. Madam Speaker, maybe this 2010 amendment, this 2020 amendment We may have another one next year and even the other year. And therefore, I support this bill, more specifically because of a number of clauses here, one of which that I'll start with is the elusive two-third gender principle. You remember last year, Madam Speaker, I think many of my colleagues have spoken to this, the fact that there was an advisory from the Chief Justice Maraga that Parliament was supposed to be disbanded for not meeting the two-third gender rule. And in this case, it was going to be so costly to our country. And in this case, I think this time we cannot afford to wait for such for another advisory again when we have an opportunity such as this to actually amend our constitution. Madam Speaker, you spoke to the issue of the fact that under Clause 7, where political parties, in this case, are compelled to ensure that in their list, that is the immediate two-third gender, you say there are holes in it. However, I want to say it is better a provision than no provision at all. Because where there has been no provision, women have had a challenge, more specifically because women do not have a level playing ground, just like men when it comes to elective position. Madam Speaker, I'm more excited about Clause 4 that amended Article 98, where there shall be election of one man, one woman in the Senate. I've had some of my colleagues feeling that this house will be floated. There'll be so many legislators in this house. I think we are only short of about 15 or 16 of them. And in this case, when we talk about the female gender, I think this is the right time that we should bring on board the 52% of the population that has been excluded. I know based on this, we shall progressively achieve the two-third gender rule. And Madam Speaker, the only sad side of this is the fact that there is no clear-cut way in the National Assembly where we are going to achieve the two-third gender rule. Provision is there that we may end up nominating maybe 103 women. I would have loved if we had left the 47 women who was having some kitty. That kitty in this case was going a long way to actually improve the lives of women down in the villages. And I think in that area we lost, because when it comes to nomination, many of my colleagues Argura has spoken to this, that it is actually a challenge. I think this is sweet melody to me, more specifically because in the last 1 year I've lost voting rights myself. I cannot vote as a member of Bomet delegation because of receiving a letter from the head of my delegation that I cannot vote anymore. This is one of the challenges that affects a nominated member. And even in addition to this, any nominated member in this case cannot even have an independent mind. I think I do not want to explain and expand my explanation, but then there are very many other examples that can be given to explain the fact that nomination that has affected majorly the women, because in most cases, looking at this house, the larger number that has been nominated, say for areas of PWT, youths, has been that of women, and these women have been subjected to a lot of challenges. Madam Speaker, one other very important clause is Clause 49 that amends Chapter 12 of BFM Act, and this one is a very interesting clause for that matter because of the fact that it is speaking to issues revenue allocation to the counties. We have been having a lot of fights in this house, Madam Speaker, trying to allocate funds to the counties, a case that even last year it was more challenging. And this one is speaking to the fact that this one will use the current audited accounts by the Auditor General, and we can no longer wait. This will go a long way to actually ensure that there is reduction time in terms of waiting for funds that goes to the county. The county, Madam Speaker, are served. I think recently I saw Council of Governors complaining that 7 months have gone without any funds going to the counties, and this is an indication to show that salaries have not been paid, bills cannot be paid, and in this case, even projects that were started cannot be completed. Therefore, people cannot have, or in this case, get fairly for their money. This is a major challenge to the extent that, Madam Speaker, we have had even people having a reservation to go and carry out any projects in the counties because they feel they cannot be paid in. Critical because it is addressing the problems of youth. Youth in this case constitutes over 75% of the population of this country, and many of them are educated and unemployed. Madam Speaker, there is already creation of youth commission that shall be speaking about issues that are affecting youths. That is the 4-year grace period after completing university, and even for the graduate startups and other startup businesses, they have got 7 years tax holiday. Me, as a chair of Education Committee, I've been meeting a lot of graduates that have been complaining in the past about payment of loans that they are required to use in their education in the universities. And I think this shall go a long way to actually cure this particular challenge. Madam Speaker, Clause 10 amends Article 89 to increase the constituencies from 290 to 360. While this has become a very contentious issue from my colleagues right from the entire morning up to now, Madam Speaker, I want to say, while we feel that the IEPC function has been usurped, I think it is not the end. We still have a lot of work to be done to these 70 constituencies that were added. Me, as a senator coming from Bomet County, I'm very proud because of the fact that I'm a supporter of PPI, and at the same time, my county is gaining 2 constituencies. This, in this case, is assuring my county of improved representation, improved resource allocation, and Madam Speaker, this one will also actualize what we normally call 1/4, 1 man, 1 shilling. Madam Speaker, it could not have come at a better time like this. Clause 44, Madam Speaker, amend Article 172 to create the office of the Ombudsman. Many of my colleagues have actually disagreed with this and actually felt that it was not good. While the Judiciary forms another arm of the government, it in this case has got to show a lot of efficiency. I think the only major challenge here is the appointing authority of the Ombudsman. However, office of the Ombudsman, if in this case it is well streamlined, will go a long way to ensure transparency and accountability in the Judiciary. Madam Speaker, there has been a lot of backlog of cases, some of them going as far as 10 years. And sometimes maybe we are talking about a shortage of charges, but some of the cases we look at them and has been affected by, in this case, some kind of corrupt practices that were going on there. That is with due respect for my colleagues, the colleagues, the learned colleagues who are here. I want to say that this office of the Ombudsman should be streamlined so that in this case we have the people of this country can receive service, judicial service, in a seamless and efficient manner. However, I want to say that while that is a challenge, there are many good things when we have an oversighting authority to every institution. Madam Speaker, because of these few provisions that I've spoken to. I support this bill, and in this case, I'm looking forward to this bill passing because it shall actually improve the living standards of the people of this country. Thank you, Madam Speaker.
Senator Masitsa Naomi Shionga.
Thank you, Madam Speaker, for giving me this opportunity to talk about or to express my submission to this Constitutional of Kenya Amendment Bill 2020, sorry. Madam Speaker, I want to start by thanking the sponsors of this bill through the handshake that we have had many of the awaited fruit that we have been yearning for. Madam Speaker, in the same tune, I would like to thank the committee that has submitted its report to this House through the chair of the legal affairs in this room or in this House. Madam Speaker, to start with, I will touch on a few issues, especially in my submission to this particular bill. I'll talk about the creation of the new 70 counties, the gender issue, the role of Senate, where I am now, and how it is in the current constitution and where this bill will take it. I'll talk about devolution, Madam Speaker, and funding, the increase of resources in the counties, especially the ward fund and the county assembly fund, the youth cane and marginalized, in other submissions that I will do. Madam Speaker, I will not evade in my submission to talk about corruption, which I like as a topic. Madam Speaker, I want to start by saying that the gender issue in this country.
Order, Senator Naomi. You will have a balance of 18 minutes when this matter comes next. Honorable Senators, it is now 6:30 p.m., time to interrupt the business of the House. The House, subject to a special sitting being gazetted, the House therefore stands adjourned until Tuesday, 11th May 2021 at 10 a.m.
Guidance to treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to advance the peace, prosperity, and welfare of our country and of those whose interests you have committed to our charge. Amen.
Order number 1, communication from the chair. Order number 2, messages.
Okay, honorable senators, I have a message on the passage of the Division of Revenue Bill, National Assembly Bill number 7 of 2021. I wish to report to the Senate that pursuant to Standing Order number 41, 3, and 4, I have received the following message from the Speaker of the National Assembly regarding the passage by the National Assembly of the Division of Revenue Bill, National Assembly Bill number 7 of 2021. Pursuant to the provisions of Standing Orders 41.1 of the National Assembly Standing Orders, I hereby convey the following message from the National Assembly. Whereas the Division of Revenue Bill, National Assembly Bill number 7 of 2021 was considered and passed by the National Assembly without amendments on Tuesday, 23rd March 2021, and referred to the Senate for consideration on Wednesday, 24th March 2021, and whereas the Senate considered and passed the said bill with an amendment to the schedule on Tuesday, 13th April 2021, and referred it back to the National Assembly for consideration in accordance with the provisions of Article 112(1)(b) of the Constitution. Further, whereas the National Assembly considered and approved the Senate amendment to the schedule of the said bill without amendment on Wednesday, 28th April 2021, now therefore this concludes the bicameral consideration of the bill, and in accordance with the provisions of Article 112(2) and of the Constitution and Standing Order 141A of the National Assembly Standing Orders, I will hereby proceed to present the said bill to His Excellency the President for assent. I thank you. Next order.
Order number 3, the Constitution of Kenya Amendment Bill 2020, second reading.
Senator Cheriot, you have 2 minutes. The records tell me something different.
Thank you, Mr. Speaker. Mr. Speaker, I'll wrap up my thoughts. I was speaking to the paradox and the irony that is in this Constitution Amendment Bill, in that Article 3, Mr. Speaker, it speaks about a shared prosperity for this nation. Yet, if you move downwards to Article 50, it returns us back to 1965, Sessional Paper number 10, where back then it was allowed, Mr. Speaker, for people to imagine that you can pay more premium on people, but consider nothing in terms of the vast lands that this country has. Back then in 1965, that was allowed, but not anymore. Think about even a simple project, Mr. Speaker, like the Lake Turkana Wind Power in Marsabit County. That project generates billions of shillings to this country, more than some of these counties that are filled with people, but the only thing they give to Kenya is potatoes. So, Mr. Speaker, this attitude of disparaging and looking down on counties that are least populated, that we now have brought and want to put it as a constitutional principle. And I pointed out before we took a break, Mr. Speaker, that even the tabulation of this proposal is not possible. If you run it on an Excel sheet, it gives you something called the circular reference error. It turns out to 0, because the more you reduce from certain counties to add to others, that balance will never be achieved, Mr. Speaker. Therefore, I'll conclude by saying the following. What are our options as a House, Mr. Speaker? I do not think this House lacks intelligent people to guide the country in terms of what to do with such a constitutional amendment bill. The only problem are the phone calls that keeps on coming, this thing called party position, and so many of these things that interfere with the independent thinking of members of this House. I can bet you, Mr. Speaker, that if you are to throw phones out of this House and give us 6 hours, as members of this House, we will give a document that will give prosperity to Kenya the way we have been dreaming about. Please, Mr. Speaker, I want to plead with our colleagues, and I know that there are some of our colleagues that are at this point in time working on amendments to this particular document. If we get to that particular point, and I believe we will, let us support them so that we do something right and justful for the people of Kenya. Otherwise, we'll be left with no option but to reject it in total, Mr. Speaker.
Senator Wambua.
Speaker, I thank you for these opportunities to contribute to this bill. Mr. Speaker, I want to begin by saying, Mr. Speaker, that a very important call has come through for all of us, as senators in this chamber. Mr. Speaker, it is a call to make a choice between moving this country to confront the challenges that we face together, or profile this country as a patchwork of winning communities and losing communities, Mr. Speaker, and that this is not the first time that this call is coming through, Mr. Speaker. This call came through last year, and we demonstrated as a House that we have what it takes to put Kenya first and ensure a win-win outcome for purposes of the sharing of revenue among counties. The Speaker, I have taken a lot of time to go through both the report and the bill. And the Speaker, I want to begin my contribution on this confusion arising around the popular initiative as captured in Section 257 of the Constitution. Mr. Speaker, I have heard very distinguished colleagues, most of them lawyers, including, and Madam Speaker, I would request that the Senator of Gitui be heard in silence.
Let's consult in low tones. Order, members. Let's consult in low tones.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, I said I have had conversations among my colleagues on the matter of this being a popular initiative. And that, Mr. Speaker, no less than the chair of the co-chair of the joint committee went on record and said that the committee really agonized over whether really this was a popular initiative and how to deal with the bill. Mr. Speaker, I want to go on record that, Mr. Speaker, the body, the spirit, the mind, the soul of this document, the bill, is executive. That I must go on record. And that, Mr. Speaker, what has happened is that this bill has been clothed with our Wanjigo dress. When it speaks, you realize that's not Wanjigo's voice. It's a strong, heavy voice. This is an executive initiative. Let's just admit that and then process it as such. The Speaker, having said that, I want to say that the proponents of this bill, and the committee has captured it very well, have said that some 29 or so counties should have additional constituencies, but an expert opinion from the Kenya National Bureau of Statistics has brought evidence before the Joint Committee, and it is captured in the report, that 6 counties, including Meru, Kitui, Bungoma, Homa Bay, Kisii, and Nairobi City County, have been unjustifiably denied additional constituencies. The Speaker, that having been captured in the report as a submission by the Kenya National Bureau of Statistics,
the committee has taken the next bold step, and they have gone on record and said that the omission of constituencies and the allocation of those constituencies in the counties is unconstitutional. Mr. Speaker, I have a small challenge, Mr. Speaker. When the committee, in their report, tell us that we should go ahead and pass the bill. And my challenge is simple, Mr. Speaker. When the chairman of the co-chair of the joint committee stood here, he admitted that there are even typographical errors, reference errors. And I heard the co-chair, Mr. Speaker, to my dismay, asking and pleading to be allowed to harmonize the errors. And the question that I'm asking myself, Mr. Speaker, is who is supposed to give us the permission to do our work? Because, Mr. Speaker, the people of Kenya, under Article 1 of the Constitution, have delegated their legislative sovereignty and authority to us, the elected leaders. Yes, the people of Kenya, through collection of signatures and views, have said what it is that they want to be done on this document. But, Mr. Speaker, as a House of Parliament, and I'm very sure the executive must be very happy to hear senators and members of the National Assembly seeking permission from I don't know who to do their job. Mr. Speaker, we have a bill before us. The processing of the bill is captured both in the Constitution and in our own standing orders, Mr. Speaker. And I will propose that, Mr. Speaker, that we debate this bill with a very open mind of correcting the mistakes and the wrongs that have been committed in this bill. Mr. Speaker, I want to continue by saying that to the extent, the Speaker, and arguments have flown across here. Some senators have said that they are more than senators of their counties. Others have said that their first recourse is to their counties. Mr. Speaker, I want to go on record and say that the only reason that I am here is because the great people of Kitui County gave me the mandate to represent them and their interests in this Senate. And so, Mr. Speaker, when the Kenya National Bureau of Statistics, the legal and legitimate body that is a custodian of population data, says that Kitui County should have been given an additional constituency, when the report of the Joint Justice and Legal Affairs Committee captures that in their final report, Mr. Speaker, I will look very, very foolish, and I have no intention of looking foolish, to stand against such a verdict. Mr. Speaker, I stand here to say that the second schedule of the bill, page 26, 27, and 28, the Speaker, creates unnecessary confusion, and as a House of Parliament, we should be able to expurge the second schedule from this bill and leave the IEBC to do the work of allocating constituencies in counties using the parameters as set out in the Constitution. Another thing that, Mr. Speaker, that's a bit baffling about this bill is that the bill, Mr. Speaker, seeks to amend the Constitution 2010. A constitution that is leaving, a constitution
that we are using to govern this country. A bill seeks to amend the Constitution. But we are being told, Mr. Speaker, and I don't know who is saying this, that we cannot amend that bill that seeks to amend the Constitution. The Speaker, that sounds very, very absurd to me, and I want to go on record and say that to the extent, Mr. Speaker, that Schedule 2 continues to be part of this bill, that schedule that denies my county an extra constituency, to the extent that we don't have that extra constituency, Mr. Speaker, as the Senator of Kitui County, I will oppose this bill. Mr. Speaker, there is the issue of the Kenya National Police Service Commission and the Office of the Inspector General of Police. The Speaker, some of these things are just self-explanatory. Article 245 and 246 of the Constitution, Mr. Speaker, establish and define the roles and responsibilities of both the National Police Service Commission and the Office of the Inspector General of Police. The Speaker, an attempt under Clause 66 and 67 of the proposed bill to transfer the roles and functions of the National Police Service Commission to the Office of the Inspector General of Police, the Speaker, it's an attempt to create a police state, Mr. Speaker, that you remove power and functions from a commission and you put it in the office of an individual, Mr. Speaker. To the extent that that matter, Mr. Speaker, remains in this bill, I have a problem with that. Mr. Speaker, on the issue of the judiciary, and that has been ably canvassed by the legal scholars in this House, including the co-chair, Senator Omogeni. The Speaker, there exists a procedure to discipline judges in the judiciary. That procedure, Mr. Speaker, is clearly stated in the Constitution and includes the appointment of a tribunal when it comes to the removal of a judge from office, for whatever reason, Mr. Speaker. Now, this idea that we will now have a judiciary ombudsman appointed by the President, approved by the Senate, and that office has powers to remove, to dismiss a judge by passing a tribunal, Mr. Speaker, is a serious affront to the independence of the judiciary. And the Speaker, there will be need to harmonize this document to ensure, Mr. Speaker, that much in as we want to change the Constitution to reflect the current needs and aspirations of the people of Kenya. The Speaker, it will not be done at the expense of whittling down the powers and responsibilities of certain arms of government and, Mr. Speaker, enriching the powers and responsibilities of other arms of government. Mr. Speaker, the country is watching us today. Kenyans want to know at the end of the day, what is it that we are going to do to make their lives better through this bill? The initiative, Mr. Speaker, and I must go on record on this, the initiative, Mr. Speaker, could be noble. An initiative to expand the executive and create positions of authority and influence to ensure that no part of this country feels left out in government. It's a noble thing to do. The Speaker, the initiative of ensuring that we have 35% of revenues collected nationally shared among counties is a noble idea, Mr. Speaker. Only that we may need to do a lot more in terms of administrative and policy interventions to bake a bigger cake so that we have that 5% to share among counties. But it's a noble idea, Mr. Speaker. The idea about a ward development fund, so that decisions on development of wards is not a decision of the governor, it is legislated. That, Mr. Speaker, is a noble idea. Mr. Speaker, the only thing that I have a problem with is a situation where, Mr. Speaker, amidst all these very good things that we want to do, there seems to be some mischief in trying, Mr. Speaker, and this must be said as it is, to allocate constituencies in certain areas in this country to the disadvantage of certain other areas in this country. Mr. Speaker, the import of this bill is that we are going to have at least 40 new constituencies in Mount Kenya region. And there's no problem with that, Mr. Speaker. But seeing as it were that, Mr. Speaker, out of 70 constituencies, 40 of them are going into one region. And the rest of the country has got to grapple and share the remaining 30. Mr. Speaker, that is not right. And that's what I'm saying, Mr. Speaker, it will be right that, Mr. Speaker, we allow the IEBC to use whatever parameters they are going to use to ensure that the distribution and the sharing and the allocation of these constituencies is acceptable across the board.
I'm just hearing a point of, use your, Senator Kangata, you know how to catch my eye, eh? You don't shout. So what is your point of order?
Senator Kangata, Mr. Speaker.
Where?
So, Mr. Speaker, Mr. Speaker.
Is it a point of order? Okay. What's your point of order?